All right.
Thank you. You may be seated. Good morning. This is the time set for the 2 a.m. initial appearance calendar on September 4th, 2025. Court's orders for the taking of DNA and fingerprints that was given on the first calendar of this month shall apply to all matters on this calendar. I will call you each one at a time to the podium. I'll provide a second name to sit in the chair outside of this room. I will let you know what you were here for, if I have appointed an attorney, if you have a bond, and what your release conditions are. If we can start with Christopher to the podium and Colin to the chair. May I get your name and date of birth?
Christopher Francio, 0519-1990.
Thank you, sir. It does look like you are here on 2 probation violation warrants that were issued for you with allegations that you violated terms 7 and 15 of your probation. I am going to appoint an attorney to represent you and set a probation revocation hearing September 10th at 8:30 a.m. In your first case, you have a secured appearance bond in the amount of $500. However, in the second case, you are being held non-bondable. So even if you were to post the bond on the first case, you would be held in custody until at least your probation revocation hearing on September 10th at 8:30. All of this information will be in your paperwork, sir. Did you have any questions? Okay, if you'll take a step to your left, the officer will get you that paperwork. Colin to the podium, Vanessa to the chair.
Good morning.
Good morning. May I get your name and date of birth?
Colin Dwight Hope, March 30th, 1981.
Thank you, sir. It does look like you are here on a grand jury warrant that was issued. It has an offense date of August 19th, 2023, and it is for 1 count of aggravated assault with a deadly weapon or dangerous instrument, a Class 3 felony, and 2 counts of endangerment, a Class 6 felony. I am appointing an attorney to represent you and setting an arraignment hearing September 11th at 8:30. In this case, you have a secured appearance bond in the amount of $50,000. In the event you do post that bond, you'll be released to the supervision of pretrial services. You'll have alcohol, drug testing, and monitoring, and you'll also have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. You may not possess weapons or alcohol. All of that will be in your paperwork, sir. Did you have any questions?
Ma'am, I'm not in no situation to post that bond. I recently get a job like a month ago, and I barely catch him back up and stuff. And I alone. I don't have no family, no get to assist me. And
if bond is not posted, then you would remain in custody until at least your next hearing on September 11th. Any further questions, sir? Okay, if you'll take a step to your left, the officer will get you that paperwork. Vanessa to the podium and Anna to the chair. Let me get your name and date of birth.
Vanessa Armour, 2/19/1987.
Thank you, ma'am. It does look like you are here on a failure to appear bench warrant. You have some pending charges related to taking the identity of another and fraud of a credit card. I'm going to affirm the attorney that was previously appointed to represent you and set a status conference September 11th at 8:30 a.m. You do have a secured appearance bond in the amount of $10,000. In the event you post that bond, you have written conditions of release. You may not return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness. You may not possess weapons. And then, of course, you'll need to ensure you attend all of your hearings. If you fail to appear, another warrant would issue and you'll forfeit any bond you posted. Did you have any questions? Okay, just step to your left, the officer will get you that paperwork. Anna to the podium, Leroy to the chair. May I get your name and date of birth?
Anna Margarita Lopez, 8/11/1990.
Thank you, ma'am. You are here on 2 probation violation warrants with allegations that you violated terms 3, 4, 5, and 15. I am appointing an attorney to represent you and setting a probation revocation hearing September 10th at 8:30. That applies to both cases. You have a secured appearance bond in the amount of $500 in one case, $250 in the other, for a total of $750. In the event you post that bond, you will have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. All of this will be in your paperwork. Did you have any questions?
No.
Okay, if you'll step to your left, the officer will give you your paperwork. Leroy to the podium, Elijah to the chair. May I get your name and date of birth?
Leroy Johnson, 31078.
Thank you, sir. It does look like you are here on 3 cases. The first case is new charges. The other cases are your probation cases. Your new charges are for 1 count of narcotic drug possession, Class 4 felony, 1 count of criminal trespass in the first degree, a Class 6 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. For purposes of today's hearing, I'm not finding probable cause for the narcotic drugs or the drug paraphernalia. That does not mean that these charges are dismissed. They may test the substance and move forward. I am going to find probable cause for the criminal trespass. On your 2 probation cases, anytime you're picked up for a new offense, it's a Term 1 violation. I'm going to appoint counsel in all of your cases. You're going to have a status conference and a probation revocation hearing on September 10th at 8:30. And then you'll also have a preliminary hearing on September 12th at 8:30. So you have 2 hearing dates coming up for the 3 cases. In your new charges, you have a bond of $50. In your probation cases, it's $250 each. That's a total bond of $550 between all 3 cases. In the event you post that bond, you'll have written conditions of release. You may not return to the scene of any alleged crime. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. All of that will be in your paperwork, sir. Did you have any questions?
Well, the only thing is, I remember going in my pocket. I didn't have no drugs with me.
Like I said, I didn't find probable cause for those charges. I don't have enough information at this time. So again, they may move forward with it. They may provide additional information to your attorney at the next hearing, but for purposes of today, I'm not finding probable cause for those charges.
All right.
Okay, thank you, sir. Just step to your left, the officer will get you that paperwork. Elijah Walker to the podium and Albert Adams to the chair. May I get your name and date of birth?
Elijah Walker, September 20th, 1998.
Thank you, sir. You're here on a probation violation warrant with allegations you violated terms 3, 4, 5, and 15. I am appointing an attorney to represent you and setting a probation revocation hearing September 10th at 8:30. In this case, you do have a secured appearance bond in the amount of $500. It does look like you were previously seen on August 31st. I'm not sure the status of that case, but if you still have a bond on that case, this would be in addition to that. If you post that bond, you do have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 24 hours of release. All of this will be included in your paperwork. Sir, did you have any questions?
No, that'd be it.
Okay, if you'll step to your left, officer, we'll get you that paperwork.
Thank you.
Albert Adams to the podium, Richard to the chair.
Albert Adams, 1/20/1989.
Thank you, sir. It does look like you are here on a direct complaint that was filed. It has an offense date of April 10th, 2025. It is for 1 count of dangerous drug possession and 1 count of narcotic drug possession and 1 count of possession of a weapon by a prohibited person. Those are all Class 4 felonies, and then 1 count of theft, control of stolen property, a Class 6 felony. I am appointing an attorney to represent you, and I'm going to give you a couple of hearings in the downtown Superior Courthouse. You will have a status conference September 10th at 8:30, a preliminary hearing September 12th at 8:30. In this case, you have a secured appearance bond in the amount of $500. It does look like you were previously seen by this court August 26th, so this would be in addition to any bond if those haven't been posted or you haven't been released on those cases. In the event bond is posted, you do have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. All of that will be in your paperwork, sir. Did you have any questions?
No, ma'am.
Okay, just step to your left, the officer will get you that paperwork. Richard to the podium and Bradley to the chair. Can I get your name and date of birth?
June 19th, 1976, Richard Delfinato.
Thank you, sir. It does look like you are here on a child support arrest warrant that was issued for you. This will be a little bit different than the cases you've heard prior to now. Because it is a child support arrest warrant, you have what is called a purge instead of a bond. You have a purge of $400. In the event you do post that purge, you will not get it back. It will apply towards your child support arrears or child support payments that you owe. I'm going to set a hearing in the downtown Superior Courthouse on September 11th at 10 a.m. Because this case is civil in nature, you're not entitled to court-appointed counsel, but you can hire an attorney if you would like. Did you have any questions?
Yes, ma'am. I have my daughter at home. I'm a single parent. I never knew about this. I just went to court and I paid to have that warrant squashed. That's why I don't know why I'm here.
So I do see that you filed a request with the court to quash the warrant. However, the court denied your request.
I wasn't even aware of that, or I would have. But I do have the money to bond out on my card. I just got paid today. I'm at work. Staying here till the 11th is going to cost me my job and put me and my daughter homeless. I don't know how else I'm supposed to do that. But if I can get to my card, I can bond myself out right now.
So you won't be able to get access to your belongings. If you had it in cash when you came in, then that will be on your account and you could apply it that way typically. Otherwise, when you get to processing, they'll give you access to a telephone and you can contact family or friends to get that posted. Once that is posted, you will be released from custody, but you'll need to ensure you attend that hearing on September 11th because if you fail to appear, another warrant will issue and another purge will be placed on this. Because this is a child support arrest warrant, it is not within my discretion to change it or release you without having that posted.
But, ma'am, I have paperwork inside my thing saying that I don't owe child support, that I paid it off in full and satisfaction. That's why I don't understand any of this.
So I did review that. What happened in your case is it looks like when your case initiated back in the 90s, in 1996, a judgment was entered against you in the amount of $3,564. A lot of times when that happens, it's for past support prior to the entry of your child support obligation. A judgment is entered against you. There was a satisfaction of judgment indicating you paid off that judgment that was entered in 1996. That does not mean that any child support due after that judgment was entered has been paid in full. And based on the records and the fact that a warrant issued after that judgment was filed, they have indicated that you do still have an arrears balance. It's just that you paid off one judgment, but not that you paid off your entire child support case.
Okay.
So if you have any questions regarding your remaining balance, you can always contact the Department of Economic Security or the Division of Child Support Services, and they can give you a better update on what your arrears balance is, and you'll see where you paid off the judgment that was entered in 1996, and then determine how much you owe that hasn't been paid since the entry of your order in 1996.
But also, they're also taking money out of my checks, too. So, I mean, I don't know.
And they could have a wage assignment issued for you, but it looks like you failed to appear at a hearing. And anytime you fail to appear at a hearing, then a child support arrest warrant will issue.
Man, when that date, I actually was on a phone call with them. That's what I don't understand. Like, when they called, I was waiting for that phone call. They were supposed to have reset that, but never even gave me another date.
So I'm looking at the minute entry, and it just indicates that you failed to appear. So it doesn't indicate that you were ever on the line at the time of the hearing, and as a result of that, the warrant issued. It does look like this is back from May of 2024.
Yes, ma'am. I remember 1931 Tonto. I remember being out there waiting on the phone with him. They actually asked for my name, waited, and I called the office and did all that. They were supposed to have rescheduled it, some other, unlegit reasons why. But I'm a single parent. I already made that. I'm not trying to lose my daughter or my home.
And I do understand that. And as I mentioned earlier, it's not within my discretion. The law requires me to hold you on this purge because it is a child support case. So you will have to pay that before being released from custody.
And so I have to keep paying the child support, even though my kids are 30 and 31, Your Honor. I have an 11-year-old daughter at home I take care of by myself.
So if you still have child support arrears, in Arizona, child support obligations do not get waived or get removed just at the time the children become adults. The arrears will still continue to accrue plus a 10% interest here. So if you didn't pay all of it when it was due and owing, then you will continue to owe that until it is paid in full.
So, ma'am, I've tried to deal with the child's mom to get it, but she has rights over the interest. I don't know if that's right either.
That is correct.
But how is that, though? Ain't that a little too much power to have over somebody's life?
So
For kids?
statutorily, when you don't pay your child support on time, then there's a 10% interest accrual. That 10% interest goes to the party the money is due and owing to. If the other party is not willing to waive it, then they are entitled to collect that.
So basically she has that much control over my life and what I can do for my daughter and myself. That's just crazy to me. But ma'am, I hear you. I respect that. Thank you. And I'm gonna bond out.
Thank you, sir. If you'll step to your left, they'll give you that paperwork. Bradley to the podium, Jeffrey to the chair. Let me get your name and date of birth.
Bradley Bryant, September 17, 2002.
Thank you, sir. It does look like you are here on two cases. You have a new case. It is a municipal court case for one count of criminal trespass, a Class 3 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have an arraignment hearing September 9th at 9 a.m. in the Peoria Municipal Court, and you have a $50 bond on that case. It looks like you're also currently on probation, and so when you were picked up for a new offense, that is a Term 1 violation of your probation. So I'm going to appoint an attorney to represent you in that case and set a probation revocation hearing September 10th at 8:30. That hearing will be in the downtown Superior Courthouse, and you have a bond of $250. So between your two cases, you have a total secured appearance bond in the amount of $300. In the event you do post that bond, you have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours. And because this is a criminal trespass case, you may not return to the scene of any alleged crime, okay? All of that will be in your paperwork. Did you have any questions?
No.
Okay, just take a step to your left. The officer will get you that paperwork.
Okay.
Jeffrey to the podium, Andre to the chair. May I get your name and date of birth?
Jeffrey Richards, 11/17/67.
Thank you, sir. You are here on a new case. It is for one count of dangerous drug possession, a Class 4 felony, and one count of drug paraphernalia violation, a Class 6 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You will have a status conference September 18th at 8:30 and a preliminary hearing September 22nd at 8:30. I am going to release you to the supervision of pretrial services. You will have written conditions of release. You may not possess any drugs without a valid prescription. You may not drive a motor vehicle without a valid driver's license. In addition to your court paperwork, you're going to get an envelope. You will need to read those instructions and contact pretrial services once you've been released, and then ensure you attend all of your hearings, because if you fail to appear, a warrant will issue and you'll be held on bond at your next hearing. Did you have any questions?
No.
Okay, if you'll take a step to your left, the officer will get you that
All right.
paperwork. Thank you, sir.
Thank you.
Andre Hayward to the podium, Ryan to the chair. Can I get your name and date of birth?
Andre Hayward, 11/2/59.
Can you repeat your date of birth?
11/2/59.
Thank you, sir. It
19.
does look like you are here on a direct complaint. It has an offense date of October 7th, 2024 for one count of aggravated assault involving a deadly weapon or dangerous instrument, a Class 3 felony. I am going to appoint an attorney to represent you and give you a couple of hearing dates. You will have a status conference September 18th at 8:30, a preliminary hearing September 22nd at 8:30, both in the downtown Superior Courthouse. I'm going to release you to the supervision of pretrial services. You will have written conditions of release. You may not initiate contact with any alleged victim, complainant, or witness. You may not possess weapons. And then you'll get an envelope with your paperwork. You'll need to read those instructions and contact pretrial services once you've been released, and then ensure you attend all of your hearings. If you fail to appear at any of them, a warrant will issue and you will be held on bond at your next hearing. Did you have any questions?
Yeah, I'm wondering who's pressing charges against me on this other stuff. I don't even remember it, basically.
Let me see if I
Who's
can take a
pressing
look.
charges and,
Do you know what the fact pattern is, what happened, or are you unaware of the situation?
that's what I'm here
It looks like
Mm-hmm.
a situation that took place on the I-10 7th Avenue off-ramp. There was an accident between a Grand Marquis and a Chevy Tahoe,
Oh, shit, okay.
and then there was an exchange of words, and there was a verbal altercation, and then they reported that
Mm-hmm.
somebody hit him with their vehicle. So it looks like it was some sort of vehicle altercation that took place on the I-10. That's what this is related to.
Is that headed which way, man?
It says the person that reported the incident had hit him with his vehicle and drove northbound. It looks like maybe an allegation of some sort of hit and run situation on October 7th of 2024.
2024.
Yes, so last October, about a year ago.
Yeah, I don't remember that. Man, that's crazy.
Do you drive either of those vehicles? Well, don't answer that. Talk to your attorney about the situation. I'm releasing you. Just make sure you go to those hearings. If you fail to appear at those hearings, a warrant will issue, okay?
That's fine.
All right. If you'll step to your left, the officer will get you that
Do I have
paperwork.
to pay any restitution or anything like that?
Well, at this time, you haven't been found guilty of anything, so
Oh.
there's no restitution, and I'm not placing a bond to be released.
Okay.
Okay?
So I'll be released today.
Yeah.
Thank you,
All
ma'am.
right. Thank you. Ryan to the podium, Miguel to the chair.
Ryan Colati, 61287.
Thank you, sir. It does look like you are here on a new case. It is for 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. For purposes of today's hearing, I'm not finding probable cause for the dangerous drug. The allegations indicate that the drug found was fentanyl, which is a narcotic drug under Arizona law, so I will not be finding probable cause for that. I am finding probable cause for the drug paraphernalia. I'm appointing an attorney to represent you and setting a status conference September 18th at 8:30, a preliminary hearing September 22nd at 8:30. I am releasing you today on your own recognizance. That is your promise to appear at these hearings. You do have written conditions of release. You may not possess any drugs without a valid prescription. You may not drive a motor vehicle without a valid driver's license, and you need to ensure you attend these hearings. If you fail to appear, a warrant will issue and you'll be held on bond at your next hearing. Did you have any questions?
No, ma'am.
Okay, so take a step to your left. The officer will get you that paperwork. Miguel to the podium. Good morning. Do I have a Spanish interpreter on the line?
Español.
Yes, of course.
All right, I have one case. Are you ready to begin, sir?
Of course, be happy to assist.
Good evening, sir. May I please get your name and date of birth?
Buenas noches, caballero. ¿Me puede dar su nombre y su fecha de nacimiento?
Miguel Payametrán, 1972, 05, 23.
¿Refiere usted a mayo 23 de 1992?
No, 72.
Muy bien.
72.
Seré Miguel Peña Beltrán. My date of birth
Payam.
is May 23, 1972.
Thank you, sir. We are here today on a new case.
Gracias, señor. Estamos el día de hoy acá en un nuevo caso.
For 1 count of illegal control of enterprise, a Class 2 felony.
Un cargo de control ilegal de una empresa, eso es un delito grave de clase 2.
1 count of transporting dangerous drugs, a Class 3 felony.
Un cargo de transportar drogas peligrosas ilegales, un delito grave de clase 3.
1 count of possessing dangerous drugs for sale, a Class 3 felony.
Otro cargo por poseer drogas ilegales y peligrosas para venta, delito grave de clase 3.
Probable cause has been found, and I'm appointing an attorney to represent you.
Se ha encontrado causa probable, por lo cual se ha colocado un abogado para representarle.
You will have a hearing on September 10th and September 12th at 8:30 a.m.
Usted va a tener audiencias en septiembre 10 y septiembre 12 a las 8:30 de la mañana.
You have a cash bond in the amount of $25,000.
Usted tiene una cantidad de fianza de $25,000 en efectivo.
In the event that bond is posted, you will be released to the supervision of pretrial services.
En el evento que usted, si en caso usted pagase esa fianza, usted sería liberado hacia los servicios de prejuicio.
And they will place an electronic monitoring system.
Ellos le colocarían a usted un sistema de monitoreo electrónico.
You are not to possess drugs without a valid prescription.
Usted no debe poseer ninguna droga sin una receta o prescripción válida.
And you are not to drive a vehicle without a valid driver's license.
Y no debe conducir ningún vehículo sin una licencia de conducir válida.
All of this will be in your paperwork. Did you have any questions?
Todo esto estará en su papeleo. ¿Tiene usted alguna pregunta, caballero?
Tengo una pregunta. Todo eso no, yo trabajo nomás, en lo que trabajo yo en la skipping, yo trabajo en eso.
Disculpe el intérprete, ¿no se entiende su pregunta?
No, es que yo nomás me digo a mi trabajo nomás. Mi trabajo es la skipping, mantenimiento, lo que trabajo yo. Yo no trabajo en eso, en la droga, nada de eso.
It's just that I was heading to my job. I work in maintenance. I actually don't work in those things of drugs.
So the allegations today have indicated that you did sell some drugs.
Las alegaciones del día de hoy indican que usted vendió drogas, caballero.
No, yo no vendo drogas.
No, I don't sell drugs.
I've appointed an attorney to represent you, and you will meet with them on September 10th.
Le he colocado un abogado para que lo pueda representar. Usted se va a reunir con ese abogado en septiembre 10.
Ok, está bien.
That is fine.
If you will step to your left, sir, the officer will get you that paperwork.
Si usted se va a su izquierda, el oficial le va a dar el papeleo.
Ok, gracias.
Thank you.
That does conclude our Spanish matters on this calendar. I do appreciate your assistance. Feel free to disconnect.
Thank you for choosing line. Rich, have a good evening, Judge. Bye-bye.
Thank you. The remaining cases will proceed as house calls due to being a danger to self or others or unable to function. Case number 3 and 4, Luke Glassmeyer, date of birth February 21st, 1991. He is here on 2 cases. The first is a new case. It is for 20 counts of organized retail theft, a Class 4 felony. Probable cause has been found, and I'm appointing an attorney to represent him. He will have a status conference September 10th at 8:30 and a preliminary hearing September 12th at 8:30. He has a secured appearance bond in the amount of $25,000. In the event that bond is posted, he will have written conditions of release. He may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and he may not go into any Harbor Freight store. He also has a warrant from the Tolleson Municipal Court related to a shoplifting charge from April 28th, 2024. I am appointing counsel and setting an arraignment hearing September 15th at 8:30 in the Tolleson Municipal Court and affirming the secured appearance bond in the amount of $500. Again, if that bond is posted, he has written conditions of release, which include not returning to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness. Ivan Lopez, date of birth April 25th, 1992. He has 5 cases on the calendar. They are all failure to appear bench warrants that were issued. I am affirming the attorneys that were previously appointed to represent him, and I am setting a probation revocation hearing as well as a status conference on September 10th at 8:30 and a preliminary hearing September 12th at 8:30. He has a secured appearance bond in the amount of $500 in each case for a total bond of $2,500. In the event that bond is posted, he will have written conditions of release. It does include not possessing weapons or alcohol and contacting his probation officer within 72 hours. Case number 20, Omero Apreza, date of birth September 15th, 1993, is here on a new case for 1 count of narcotic drug possession, a Class 4 felony, and 1 count of criminal trespass, a Class 3 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent him. He will have a status conference September 18th at 8:30, a preliminary hearing September 22nd at 8:30. I'm releasing him to the supervision of pretrial services. He will have written conditions of release to include not returning to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and he will get an envelope with his paperwork, and he will need to contact pretrial services once released. Case number 25, Sierra Rosales, date of birth March 26, 1986. She is here on a warrant from the Santan Justice Court. It is for an offense date of June 3rd, 2023 for 1 count of shoplifting. Due to the nature of her charges, she is not entitled to court-appointed counsel. She will have an arraignment hearing September 23rd at 9 a.m. in the Santan Justice Court. I am releasing her on her own recognizance, that is her promise to appear. She does have written conditions of release to include not returning to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. Case number 6, David Montoya, date of birth February 5th, 1992. He is here on a new case for 1 count of theft means of transportation, a Class 3 felony. Probable cause has been found, and I'm appointing an attorney to represent him. He will have a status conference September 10th at 8:30, a preliminary hearing September 12th at 8:30. He has a secured appearance bond in the amount of $2,500. In the event that bond is posted, he has written conditions of release. He may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. If anything changes after I meet with any of these parties, I will update the written record. This does conclude our 2 a.m. calendar, and we will now stand in recess until 5 a.m.
All rise.
Thank you. You may be seated. Good morning. This is the time set for the 5 a.m. initial appearance calendar on September 4th, 2025. The court's orders for the taking of DNA and fingerprints that was given on the first calendar of this month shall apply to all matters on this calendar. I'll call you each one at a time to the podium. I will let you know what you are here for, if I have appointed counsel, if you have a bond, and what your release conditions are. If we could start with Brandon Miller to the podium and Benjamin Hill to the chair. Can I get your name and date of birth?
Brandon Miller, 10/20/91.
Thank you, sir. It does look like you are here on a probation violation warrant that was issued with allegations you violated terms 3 and 5 of your probation. I am appointing an attorney to represent you and setting a probation revocation hearing September 10th at 8:30. In this case, you are being held non-bondable, so you will remain in custody until that hearing. Did you have any questions?
No.
Okay, if you'll take a seat or step to your left, the officer will give you that paperwork. Benjamin Hill to the podium. Johan Villa or Villa to the chair. May I get your name and date of birth?
Benjamin Hill, January 21st, 1986.
Thank you, sir. It does look like you are here on a direct complaint that was filed. It has an offense date of January 31st, 2025 for 1 count of dangerous drug possession, a class 4 felony.
Yes, ma'am.
And 1 count of drug paraphernalia possession, a class 6 felony. I'm appointing an attorney to represent you, and I'm going to give you a couple of hearings in the downtown Superior Courthouse. You'll have a status conference September 10th at 8:30, an evidentiary hearing September 11th at 1:30, and a preliminary hearing September 12th at 8:30. At the time of this offense, you were out on felony release on a separate case, and because you were out on felony release, you're not eligible for bond today.
Okay.
The hearing set on September 11th at 1:30 is the time set to determine if bond will be set on this case. Did you have any questions?
No.
Okay, if you take a step to your left, the officer will get you that paperwork. Mr. Villa to the podium and Mr. Riley to the chair. May I get your name and date of birth?
Johan Daniel Villa, 11/11/1997.
Thank you, sir. It does look like you are here on a new case. It is for 1 count of possession of dangerous drugs for sale, a class 2 felony, 1 count of transporting dangerous drugs, a class 2 felony, 1 count of possession of narcotic drugs for sale, a class 2 felony, or excuse me, 2 counts of that, 2 counts of transporting narcotic drugs, a class 2 felony, 1 count of money laundering, a class 3 felony, and 1 count of drug paraphernalia possession, a class 6 felony. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference September 10th at 8:30, a preliminary hearing September 12th at 8:30, both in the downtown Superior Courthouse. You have a cash bond of $25,000. In the event you post that bond, you'll have written conditions of release. You may not possess drugs without a valid prescription, and you may not drive a motor vehicle without a valid driver's license. You also need to ensure you attend your hearings. If you fail to appear at any of them, a warrant will issue, and you'll forfeit any bonds you posted. Did you have any questions, sir?
What would be the full amount for the bond? Like, what do they have to pay? Is it like 10% or 5% down?
Yours is a cash bond, so it is the full $25,000.
Okay.
Anything further?
Okay.
Okay, if you'll take a step to your left, the officer will get you that paperwork. Mr. Riley to the podium. Mr. McCall to the chair. May I get your name and date of birth?
Christopher Riley, July 30th, 1996.
Thank you, sir. You are here on a new case. It is for one count of theft means of transportation, a Class 3 felony, one count of dangerous drug possession, a Class 4 felony, one count of unlawful flight from a law enforcement vehicle, a Class 5 felony, one count of drug paraphernalia possession, a Class 6 felony, one count of criminal damage, a Class 1 misdemeanor, and one count of reckless driving, a Class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference September 10th at 8:30 and a preliminary hearing September 12th at 8:30. In this case, you have a secured appearance bond in the amount of $20,000. In the event you post that bond, you have written conditions of release. You may not return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. All of that will be included in your paperwork, sir. Did you have any questions?
Okay.
Okay, if you'll take a step to your left, the officer will get you that paperwork. Mr. McCall to the podium. Eric Galto to the chair. May I get your name and date of birth?
Elijah, and my date of birth is March 25th, 2002.
And your last name?
McCall?
Thank you, sir. It does look like you are here on a new case. It is for one count of aggravated assault, a Class 3 felony, 3 counts of aggravated assault, a Class 6 felony, 3 counts of resisting arrest, physical force, a Class 6 felony, and 1 count of obstructing police, a Class 1 misdemeanor. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference September 10th at 8:30 and a preliminary hearing September 12th at 8:30. You have a secured appearance bond in the amount of $15,000. In the event you post that bond, you have written conditions of release. You may not initiate any contact with any alleged victim, complainant, or witness, and you may not possess any weapons. All of that will be in your paperwork. Did you have any questions? Okay, if you'll take a step to your left, the officer will get you that paperwork. Mr. Galto to the podium. Mr. Neum to the chair. May I get your name and date of birth?
Eric Young Galso, 12/2/1982.
Thank you, sir. It does look like you are here for some new charges. It looks like they're from July of 2025 for 2 counts of criminal damage, a Class 5 felony, 3 counts of criminal damage, a Class 6 felony, and 3 counts of criminal damage, a Class 1 misdemeanor. It looks like you were previously seen for another criminal damage charge on September 3rd, so yesterday at 5 p.m. It looks like some additional charges have been brought forth. I am finding probable cause and appointing an attorney to represent you. You're going to have a status conference September 10th at 8:30 and a preliminary hearing September 12th at 8:30. You have a secured appearance bond in this case in the amount of $5,000. That is in addition to the bond that was set yesterday. In the event you post that bond, you have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. All of that will be in your paperwork, sir. Did you have any questions? Mr. Neum to the podium, and Mr. Stevens to the chair. May I get your name and date of birth?
Shadrach Diam, 12/16/97.
Thank you, sir. And it does look like you are here on a new case. It is for 1 count of possession of a weapon by a prohibited person, a Class 4 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference September 10th at 8:30 and a preliminary hearing September 12th at 8:30. You have a secured appearance bond in the amount of $5,000. In the event you post that bond, you do have written conditions of release. You may not possess weapons. You may not possess any drugs without a valid prescription. You may not drive a motor vehicle without a valid driver's license. All of that will be in your paperwork. Did you have any questions?
I have 3 kids to get home to. How would I get home sooner?
Once you post the bond, you'll be released from custody.
All right.
Okay? If you'll take a step to your left, the officer will get you that paperwork.
You can't.
That's okay. May I get your name and date of birth?
Sean Walter Stevens, 4281.
Thank you, sir. It does look like you are here on 3 cases. It does look like they're all probation violation warrants with allegations you violated terms 3, 5 in 2 of the cases and terms 6 and 7 in the other case. I am going to appoint an attorney to represent you and set a probation revocation hearing September 10th at 8:30. That'll apply to all 3 cases. You have a bond of $500 in one case, $250 each in the other 2 cases for a total bond of $1,000. In the event you post that bond, you have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours. All of that will be in your paperwork, sir. Did you have any questions?
I do, Your Honor, it's not a question, actually. The cases were already dealt with last month. I was on the community court. Instead, they did the community court. I served my time. These are the same cases. It's actually double jeopardy. Just last month, and I'm going to right now. I'm on Rule 11 court for the same thing.
These probation warrants were issued August 22nd, 2025, so they're
Yes,
very
ma'am.
recently issued warrants.
Yes, ma'am. But the cases were already dealt with. This is the same. I don't have any open cases.
So according to the docket in each of these cases, you are currently on probation in 3 cases, and there's allegations that you violated your probation, and that's why you're here now, is for violating your probation. And so they're seeking to potentially revoke the probation in all 3 cases. And so that's why you have a probation revocation hearing on September 10th. And you have a bond of $1,000 between all 3 cases. If you do post that bond, you'd be released from custody, but then it would be your responsibility to ensure you attend that hearing. If you were to fail to appear, a warrant would issue. And then make sure that you contact your probation officer within 72 hours of release.
I understand what you said, but this is double jeopardy. I did it last month. I was on community court. I've already taken care of them. I'm now on Rule 11. So in case if there are any open cases, they would be stopped right now because of Rule 11 to prove competency. You see what I'm saying?
I understand what you're saying, and what I'm saying is these petitions to revoke were filed August 26th or August 22nd, approximately 2 weeks ago, and the court issued warrants based on these petitions to revoke. It does not indicate that any of these cases are currently in Rule 11 court. You may have an additional case that's in Rule 11 court, but you do have 3 probation cases, and you do have a bond that will need to be posted in order to be released from custody.
I don't have the probation. I'm on Rule 11. So anything that, if I had any cases, they would be stopped right now. I'm being proved competency. These are false warrants.
Okay, so I am finding that these are valid warrants, and you will have to post that bond in order to be released from custody. Please take a step to your left, and the officer will give you that paperwork. Mr. Esperanza to the podium and Mr. Moraga to the chair.
Morning, Your Honor.
May I get your name and date of birth?
My name is Mr. Ralph Esperanza, ma'am.
Date of birth?
4/22/1970.
Thank you, sir. It does look like you are here on 2 cases. Your first one is a new case. The second case is a probation case. Your first case is for a new charge of 1 count of dangerous drug possession, a Class 4 felony. And then because you're on probation, it is a Term 1 violation whenever you're picked up for a new offense. So I am finding probable cause in both cases and appointing an attorney to represent you. You will have a status conference along with a probation revocation hearing September 10th at 8:30, a preliminary hearing September 12th at 8:30, and a bond of $250 in each case for a total of $500. In the event you post that bond, you have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. All of that will be in your paperwork. Did you have any questions?
No, ma'am.
Okay, so step to your left. The officer will get you that paperwork. Thank you, sir.
All right, thank you.
Mr. Moraga to the podium. Job to the chair. Is Job in the gallery yet? Number 12.
Ethics, but I'm separate from everybody else.
Okay. Mr. Moraga, can I please get your name and date of birth?
Ronald Anthony Moraga, May 31st, 1989.
Thank you, sir. It does look like you are here on a new case. It is for 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of disobeying an order of the court, a Class 1 misdemeanor. For purposes of today's hearing, I'm not finding probable cause for the dangerous drug or drug paraphernalia. I'm only finding probable cause for disobeying an order of the court. I'm appointing an attorney to represent you and setting a status conference September 18th at 8:30. A preliminary hearing September 22nd at 8:30. I'm releasing you to the supervision of pretrial services. You do have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. And then you'll need to ensure you attend your hearings and contact pretrial services once you're released. All of that information will be in your paperwork and the envelope you received. Do you have any questions?
Yes, ma'am. Correct me if I'm wrong, please. They said they arrested me for violating my original charge, but I was nowhere near the house, ma'am. I was in a field. I was far from the house, and they came up on me, and I was on my way to rehab. I have a clinic called Family Jewish Center. And I was, my girlfriend, she's the only person that I have out here. I have no family. And she was going to help me get into rehab. And so I don't know if I like to fight that because I feel like I didn't do anything. They came up on me. I was nowhere near the property. I was off property, ma'am.
So the allegations do include that you went to the home and you knocked on the front door, and as a result of that, there was police contact and you were arrested for that. However, I have appointed an attorney to represent you in this case, and you will meet with that attorney at your next hearing on September 18th.
Oh, I should go to my rehab?
I'm sorry?
I should go to my rehab?
I am releasing you, but you need to make sure you attend your hearing on September 18th.
Oh, okay, ma'am.
Okay?
Thank you.
All right, if you'll take a step to your left, the officer will get you that paperwork.
One more question. You said under pretrial services?
Correct.
What is that?
So you'll get an envelope with your paperwork, and you will need to contact them when you leave, and they'll give you reminders to attend your hearing. They'll give you a bus pass if you need it. So you just need to stay in contact with them once you've been released.
So it's not information? Like, I don't have to drop you later?
No, I'm not ordering that. Any of that will be done.
Oh, okay. Okay, ma'am.
All right?
Thank you.
Just step to your left, the officer will get you that paperwork. Thank you.
Thank you. I'm sorry. Will I have a fine?
You don't have a bond at this time, no, sir.
A fine? Oh.
I'm sorry? I have an Abel and a Job. Who's Joseph?
What's the Joseph DeLuca?
Oh, yeah.
Number 12? And then,
Yep.
Which one would you like for Shoner?
Either one is fine.
Okay, I'll grab number 12.
Thank you. May I get your name and date of birth?
Job Trevick DeLuca, 06/03/2003.
Thank you, sir. You're here on a grand jury warrant. It does have an offense date of June 5th, 2025 for 1 count of narcotic drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of shoplifting removal of goods, a Class 1 misdemeanor. I'm appointing an attorney to represent you and setting an arraignment hearing September 11th at 8:30. In this case, you have a secured appearance bond in the amount of $500. In the event you post that bond, you will have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. All of that will be in your paperwork, sir. Did you have any questions?
No, ma'am.
Okay, if you'll take a step to your left, the officer, other way, sir, towards the officer, they'll give you that paperwork. May I get your name and date of birth?
Abel Block, May 22nd, 2000.
Thank you, sir. It does look like you are here on a probation violation warrant with allegations that you violated terms 1, 11, and 12. I'm appointing an attorney to represent you and setting a probation revocation hearing September 10th at 8:30. You do have a secured appearance bond in this case in the amount of $7,500. In the event you post that bond, you have written conditions of release. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours of release. Did you have any questions?
No, ma'am.
Okay, if you'll take a step to your left, the officer will get you that paperwork. Can I have Carlos to the podium?
Involved youth and their families.
Good morning. Do I have a Spanish interpreter on the line?
Yes, ma'am. Good morning.
Good morning. I have 2 cases on my calendar. Are you ready to begin?
Yes, ma'am.
Good evening, sir. Good morning, sir. Could I please get your name and date of birth?
Sí, buenos días, señor. ¿Se me puede dar, por favor, su nombre y fecha de nacimiento?
Carlos Jesús Montoya Campos, 3 de octubre del 2005.
It is Carlos Jesús Montoya Campos, October 3rd, 2005.
Thank you, sir. It does look like you are here on a new case.
Gracias, señor. Se ve que está aquí usted por un nuevo caso.
It is for 2 counts of possessing dangerous drugs for sale.
Dice que es por poseer 2 drogas peligrosas a la venta.
1 count of transporting dangerous drugs.
Lo que es una por transportar lo que son drogas peligrosas.
2 counts of possessing narcotic drugs.
2 por poseer lo que son drogas narcóticas.
2 counts of transporting narcotic drugs.
2 por transportar lo que son drogas narcóticas.
Those are all class 2 felonies.
Esos son ambas los que son clase 2, delito mayor.
1 count of money laundering, a class 3 felony.
Lo que es una de lavado de dinero, lo que es clase 1, delito mayor.
1 count of drug paraphernalia possession, a class 6 felony.
Lo que es oso poseer lo que es parafalanería de drogas, lo que es clase 6, delito mayor.
Probable cause has been found and I'm appointing an attorney to represent you.
Una causa probable ha sido encontrada y lo cual le voy a designar a un abogado para que lo represente.
You will have a hearing September 10th and September 12th at 8:30 a.m.
Usted va a tener lo que es la audiencia, lo que es septiembre 10 y septiembre 12 a las 8:30. Oh, sorry, ma'am, you said 8:30?
Yes, ma'am.
Sí, a las 8:30.
You have a cash bond of $25,000.
Lo cual puede salir bajo fianza con un efectivo de $25,000.
In the event you post that bond, you have written conditions of release.
Al igual, si se paga lo que es esa fianza, tiene ciertas condiciones al ser liberado.
You may not possess drugs without a valid prescription.
No puede poseer drogas sin una prescripción válida.
You may not drive a motor vehicle without a valid driver's license.
No puede conducir un vehículo sin una licencia de conducir válida.
All of this will be in your paperwork. Did you have any questions?
Y todo eso va a estar en sus documentos. ¿Tiene usted alguna pregunta?
Okay.
Okay, no.
If you will step to your left, the officer will give you your paperwork.
Si se va hacia la izquierda, el oficial le va a dar todos sus documentos.
All right, thank you.
If I could have Mr. Rosales to the podium.
Sí, sí, puedo llamar al señor Rosales para lo que es el podio.
Buenos días.
Good morning.
Good morning. Could I please get your name and date of birth?
Buenos días, ¿se puede dar por favor su nombre y fecha de nacimiento?
Jesús Antonio Rosales Roa, 15 de noviembre de 1994.
Oh, do you mind if I ask him to repeat that name? I'm sorry.
Of course.
¿Me puede repetir su nombre, perdón?
Jesús Antonio Rosales Roa.
Es Jesús Antonio Rosales Roa, November 15, 1994.
Thank you, sir. You're here today on a new case.
Gracias, señor. Usted está aquí con un nuevo caso.
One count of unlawful flight from a law enforcement vehicle.
Sorry, do you mind repeating?
One count of unlawful flight from a law enforcement vehicle.
Uno me que está utilizando lo que es un vehículo por no prestarle atención a lo que es un policía.
Two counts of theft means of transportation.
Dos por robo de transportación.
Those are all class 5 felonies.
Los cuales son clase 5 delito mayor.
One count of resisting arrest, a class 6 felony.
Otro por resistir lo que es arresto, lo que es número 6 delito mayor.
And one count of theft, a class 1 misdemeanor.
Y lo que es robo, lo que es un delito menor.
Probable cause has been found, and I'm appointing an attorney to represent you.
Causa probable ha sido encontrada, entonces se puede asignarle un abogado para que lo represente.
You will have a hearing on September 10th and September 12th at 8:30.
Usted va a tener su audiencia septiembre 10 y septiembre 12 a las 8:30.
You have a secured appearance bond in the amount of $10,000.
Lo cual tiene usted que puede salir bajo fianza con el monto de $10,000.
If you post that bond, you have written conditions of release.
Y si usted es liberado con ese monto para salir bajo fianza, tiene condiciones escritas para la liberación.
You may not return to the scene of the crime or contact the victim.
Usted no puede regresar a la escena del crimen o contactar a la víctima.
All of this will be in your paperwork. Did you have any questions?
Y todo eso va a estar en sus documentos. ¿Tiene preguntas? No.
Thank you, sir. If you will step to your left, the officer will get you that paperwork.
Gracias. Se puede ir a la izquierda. El oficial le va a dar los documentos.
Gracias.
Thank you.
That does conclude our Spanish matters this morning. I do appreciate your assistance. Feel free to disconnect at your convenience.
No, probably have a good day.
The remaining cases will proceed as house calls due to being unable to function or being a danger to self or others. Case number 20, Lucas Alcala, date of birth May 9th, 1987, is here on a new case for one count of reckless driving, a class 2 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent him. He will have an arraignment hearing in Surprise Municipal Court on September 9th at 1:30. He has a secured appearance bond in the amount of $1,000. In the event bond is posted, he has written conditions of release to include not returning to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. Case number 4, Adam Hurtado, date of birth November 24th, 1994, is here on a new case for 2 counts of attempted criminal damage, a class 1 misdemeanor. 3 counts of attempted disorderly conduct fighting, a Class 1 misdemeanor. Probable cause has been found, and I am appointing an attorney to represent him. I am setting an arraignment hearing in the Goodyear Municipal Court on September 10th at 8:30 in the morning. He has a secured appearance bond in the amount of $1,500. In the event bond is posted, he will have written conditions of release. It will include not returning to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. Case number 11, Deshaun Hall, date of birth October 5th, 1994, is here on a new case for 1 count of aggravated assault, a Class 3 felony, and 1 count of indecent exposure, a Class 1 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent him. We'll have a status conference September 10th at 8:30, a preliminary hearing September 12th at 8:30. He has a secured appearance bond in the amount of $25,000. In the event that bond is posted, he will be released to the supervision of pretrial services and equipped with electronic monitoring. He will have written conditions of release. He may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and he may not possess any weapons. If anything changes after I meet with him, I will update the written record, and that goes for all 3 of those parties. That does conclude our 5 a.m. calendar, and we will now stand in recess until 8 a.m. And now we do need to reprint number 4, one of the house calls. Mr. Hurtado. Yes.
Even this bag, girl?
Number six on the docket, it looks like it's someone else. It's the person that also has to, so let me make it not.
What number on the docket again?
Number 6.
Number 6?
Yeah, so starting from number 6 and then after him, the courtroom needs to be cleared. It's just due to the, victims when they came.
Okay, so.
Okay.
So after number 6, we're gonna start taking those people on? Yeah. No, I was just asking, like, we're gonna bring, those certain people after number 6? Okay. And we just move them outside after number 6?
You can be at the end. So there's courtroom already, like, everybody will be there.
Oh, so,
Yeah.
so everybody, I get what you're saying.
Oh, what I'm thinking is gonna happen, if Ash doesn't come today, they're probably gonna have me do Phoenix and have you in there. No, I know, but I'm saying if it doesn't, that's what I'm expecting, I'm thinking it's gonna happen. And then we'll switch, to totally, my Phoenix, that's working. So we'll see.
What number is your access?
I'm gonna let Holly.
Which is what Mark, I'm watching.
That's me number 2. She was in Holly till 11.
I can also see if she was coming.
No, because she was blue one. She's on his phone.
Holly to Holly.
There's no house calls, correct? There's gonna be one.
Hey, Miranda, we're more likely gonna bring back,
What number?
the ad tag for house call due to her behavior.
Number 10, because
Yeah.
she's overacting.
All right, she's gonna go, is 11 still open?
So we're gonna take her back.
Okay, I'll just take her back to 11. All right, bye. All right. I'll just take her back then. What's her name?
She's right here.
Your bed?
Her name's, Gerard.
Where can I take her back? We're gonna.
Oh my God! Don't talk to me!
All right.
Good morning, you may be seated. Okay. This is the time set for the 8 a.m. initial appearance calendar for September 4th, 2025. Is the interpreter able to hear the court? Is the interpreter able to hear the court?
Can the court hear the interpreter?
We can hear you now.
My apologies.
That's okay. So I'm not sure if you were interpreting what I previously stated. So I'm going to go ahead and restate it, okay?
Thank you.
This is the time set for the 8 a.m. initial appearance court for September 4th, 2025.
Esta es la hora prevista para la lista de comparecencias de las 8 de la mañana del 4 de septiembre 2025.
The court's orders for the taking of fingerprints and DNA samples made on the 1st of this month will apply to all matters on this calendar.
La orden emitida sobre la toma de huellas dactilares y muestras de ADN en la primera lista de comparecencias de este mes también aplicarán a las causas de hoy.
I am Commissioner Dyer, and there are a few things that I want to explain to you before we get started.
Soy la comisionada Dyer y hay algunas cosas que le quiero explicar antes de que empecemos.
First, I will call each of you to the podium one by one.
Primero les llamaré para que pasen al podio uno por uno.
I will ask you for your first and last name and your date of birth.
Le pediré que me diga su nombre y su apellido y su fecha de nacimiento.
I will then tell you why you are here today.
Después le informaré por qué se encuentra aquí hoy.
I will also let you know whether or not an attorney has been appointed to represent you.
También le informaré si es que se nombra un abogado para que le represente.
I will then tell you when your future court dates will be.
Después le informaré sus siguientes audiencias.
And I will let you know what your bond will be if you are eligible for bond.
Y si usted reúne los requisitos para que se le imponga una fianza, le dejaré saber cuál es o cuánto es.
Lastly, I will tell you what your release conditions are.
Y por último, le voy a informar sus medidas cautelares.
Some of you may have some questions while I'm providing this advisement.
Algunos de ustedes pueden que tengan preguntas mientras les estoy dando esta información.
I would first ask that you not interrupt me while I'm providing the advisement.
Primero le voy a pedir de que no me interrumpa mientras le estoy dando los avisos.
Please hold your questions until I complete the advisement.
Por favor, guarde sus preguntas hasta que termine de darle los avisos.
Your questions should only be related towards your release conditions.
Sus preguntas solamente deberían ser referentes a sus medidas cautelares.
This is a recorded proceeding. Anything that you say could be used against you.
Esta es una diligencia grabada y cualquier cosa que usted diga puede ser usada en su contra.
So any questions or statements about your case should be directed to your attorney.
Así es que cualquier pregunta o declaración que quiera hacer referente a su caso se las debe dirigir a su abogado.
Ms. Mena Contreras, will you please come to the podium inside the courtroom?
Señora Mena Contreras, pase a la sala.
Ma'am, can you please state your first and last name and your date of birth?
Señora, ¿me puede decir su primer nombre, su apellido y su fecha de nacimiento?
Ana Berta Mena Contreras, 28 de febrero del 73.
Ana Berta Mena Contreras, February 28th of 73.
You are here today for a new case.
Está usted aquí en un nuevo caso.
We're charged with 1 count of unlawful flight from law enforcement.
Y se le acusa de una fuga ilegítima de la policía,
A classified felony.
un delito categoría 5.
I did find probable cause as to that offense.
He determinado que existe un motivo fundado para vincularla a este ilícito
And I did appoint an attorney to represent you.
y he nombrado un abogado para que le represente.
You will have a status conference hearing on September 18th at 8:30.
Tiene una audiencia, una consulta de actualización septiembre 18 a las 8:30
And a preliminary hearing on September 22nd at 8:30.
y una preliminar el 22 de septiembre a las 8:30.
I am inclined to release you to pretrial services today.
El día de hoy me inclino a ponerla en libertad bajo la supervisión del Servicio de Control de Procesados,
Which means that you will be on supervised release in the community.
Eso quiere decir que estará usted bajo supervisión comunitaria.
You do have to promise to appear for your court dates.
Debe usted prometer que comparecerá a sus audiencias.
Do you promise to appear for your court dates?
¿Promete comparecer a
Sí.
sus audiencias?
Sí.
Yes. Yes.
You must comply with your release conditions and you must appear for your court dates.
Deberá usted cumplir con sus medidas cautelares y comparecer a sus audiencias.
If you fail to do so,
Si no lo hace,
a warrant will issue for your arrest and a bond would be imposed.
se emitirá una orden de detención en su contra y se impondrá una fianza.
This takes care of everything that I needed to tell you about this morning.
Esto se encarga de todo lo que le debería notificar esta mañana.
If you have no questions for me,
Si usted no tiene preguntas para mí,
please step to your left and the officer will give you your paperwork.
pase a la izquierda, por
No.
favor, y la gente le dará sus papeles.
Thank you.
Mr. Parra, can you inquire as to whether or not anybody else is in need of your services before I excuse you?
Yes, Your Honor. Buenos días, ¿hay alguien en la sala que necesite asistencia en español en esta audiencia? Levante su mano, por favor.
Nobody else needs an interpreter? Just one.
Okay, so who is it?
It's gonna be Campos, he's gonna be, one of the last ones.
Okay, Mr. Parra, we were just made aware that someone else is in need of your services. I did not realize that, or I would have had you call in towards the end of the calendar. Can you call back? Can we reach back out to you in about 30 minutes for the last matter that requires an interpreter?
Our coordinator's office can be contacted for that, Your Honor. Somebody will be available at that point.
Okay, thank you. Can you advise the gentleman that we will make arrangements for someone to assist him when we call his case?
Yes, of course. Señor Campos Cortés, soy el intérprete. Se le dispondrá un intérprete una vez de que esté listo el caso para ser llamado.
Thank you, Mr. Parra. You may be excused.
Thank you.
All right. Mr. Britt, will you please come to the podium? And Mr. Marco Contreras, will you please have a seat in the chair? Hello, sir. Can you please state your first and last name and your date of birth?
Jordan Britt, 11/2/1990.
You are here today on a probation violation warrant. I did appoint an attorney to represent you in this matter. You do have a probation revocation possible disposition hearing on September 11th at 8:30. Due to the nature of the violation of probation, I do believe that you may be facing a period of incarceration. As such, you are not entitled to bond today. You will be heard on September 11th at 8:30. How your case will proceed at that time and the issue of bond will be addressed at that time. That takes care of everything that I needed to advise you of today. If you have no questions for me, if you will please step to your left, the officer will give you your paperwork. Thank you.
And have a seat, third row, closest to the door.
Mr. Contreras, will you please come to the podium? And Mr. Bashk, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Marco Contreras, September 23rd, September 23rd, 1991.
You were here today because you have one new case. A direct complaint was filed and you have 2 warrants for failing to appear for court dates. On your new case, you were charged with 1 count of possession of a dangerous drug, a class 4 felony, and 1 count of possession of drug paraphernalia, a class 6 felony. I did find probable causes to those charges, and I did appoint an attorney to represent you. You will have a status conference hearing on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. Because you were on felony release at the time that these alleged offenses occurred by Arizona statute, you are not entitled to bond today. So I did have to schedule an evidentiary hearing for you on September 11th at 1:30. Then as to your direct complaint that was filed, you were charged with 1 count of possession of a dangerous drug, a class 4 felony. The date of this alleged offense is January 23rd, 2025. I appointed an attorney to represent you in this matter. You have a status conference hearing on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. And the direct complaint had a secured appearance bond in the amount of $250. Then, as to your 2 matters for failing to appear for your court dates, an attorney was already appointed to represent you in those matters. You will have a disposition hearing and a status hearing on September 10th at 8:30. Each of those warrants had a secured appearance bond in the amount of $2,500. Your total secured appearance bond on those 3 matters is $5,250. I would caution you against attempting to post bond since you are not bondable in the new case. Wait till after your evidentiary hearing to see if you will be bondable before you attempt to post bond. Posting bond would not secure your release. So this takes care of everything that I needed to talk to you about this morning. If you have no questions for me, if you will please step to your left, officer will give you your paperwork. Thank you.
So that means I'm staying in
Yeah.
jail? Okay, thank you.
There you go. And you're gonna sit in the third row, closest to the door.
Mr. Bask, I'm so sorry if I'm saying your last name incorrectly. If you will please come to the podium. And Mr. Holland, if you'll please have a seat in the chair. Hello, sir. Can you please state your first and last name and your date of birth?
Terry Bash, June 21st, 1995.
You are here today because you have a new case and then you have a warrant out of Peoria Municipal Court. On your new case, you were charged with 1 count of aggravated assault causing serious physical injury, a Class 3 felony. I did find probable cause as to that charge. I did appoint an attorney to represent you. You do have a status conference hearing on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. You have a secured appearance bond in the amount of $50,000. As to your warrant, I did appoint an attorney to represent you in that matter. You will have an arraignment hearing on September 9th you will have a, you will have a arraignment hearing on September 9th at 9 o'clock. You do have a secured appearance bond in the amount of $500. If you are able to post bond, you cannot return to the scene of the alleged crime, you cannot initiate any contact with the alleged victims, and you cannot possess any weapons. Failure to comply with your release conditions or failing to appear for your court date would result in the loss of any bond that you post. Warrants would issue for your arrest, and additional bond could be imposed. This takes care of everything that I needed to talk to you about this morning. If you have no questions for me, if you will please step to your left, officer will give you your paperwork. Thank you.
Put your arms to your sleeve. Here you go.
Mr. Holland, will you please come to the podium? And Mr. Luna Zamarana, or I'm so sorry, I'm not pronouncing your last name correctly, but if you could please have a seat in the chair. Sir, can you please state your first and last name and your date of birth?
Scott Halen, August 12, 1989.
You are here today because you have 1 new case and you have 3 probation violation warrants. I did appoint an attorney to represent you in the new case. You were charged with 1 count of possession of dangerous drugs for sale, a Class 2 felony, 1 count of escape in the 2nd degree from felony custody, a Class 2 felony, 1 count of possession of narcotic drugs for sale, a Class 2 felony, 1 count of possession of a weapon by a prohibited person, a Class 4 felony, 1 count of possession of a weapon during a drug offense, a Class 4 felony, 1 count of theft or control of stolen property, a Class 5 felony, 1 count of possession of drug paraphernalia, a Class 6 felony, and 1 count of resisting arrest, passive resistance, a Class 1 misdemeanor. I did find probable cause as to all of the charges. I did appoint an attorney to represent you in this matter. You do have a status conference hearing on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. You do have a secured appearance bond in the amount of $50,000. As to your probation violation warrants, I did appoint an attorney to represent you in all 3 matters. Each of your warrants has a secured appearance bond in the amount of $100. You will have a probation revocation possible disposition hearing on September 11th at 8:30. Between the 4 cases, you have a total secured appearance bond of $50,300. If you are able to post bond, you cannot return to the scene of the alleged crime, you cannot initiate any contact with the alleged victim, and you cannot possess any weapons. Failure to comply with your release conditions or appear for your court dates would result in the loss of any bond that you post. A warrant would issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to talk to you about this morning. If you have no questions for me, if you'll please step to your left, the officer will give you your paperwork. Mr. Zamorano, if you'll please come to the podium. And Ms. Maria Santa Cruz, if you'll please have a seat in the chair.
Good morning, Your Honor.
Hello, sir. Can you please state your first and last name and your date of birth?
Gabriel Luna Zamorano, October 17, 2004.
You are here today on a new case. You were charged with 1 count of aggravated assault, a Class 6 felony. I did find probable cause as to that offense, and I did appoint an attorney to represent you in this matter. You will have a status conference hearing on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. You have a secured appearance bond in the amount of $10,000. If you are able to post bond, you'll be released to pretrial services on electronic monitoring. You cannot return to the scene of the alleged crime, you cannot initiate any contact with the alleged victim, and you cannot possess any weapons. There is an order of protection that has been issued. You must comply with that. If there's an order against harassment that has been issued, you must comply with that as well. You cannot have any contact with the alleged victim. You cannot reside at the same location as the alleged victim. And you are cautioned that if you violate the no victim contact order in this case, you could be charged with aggravated harassment, which is a Class 6 felony. Failure to comply with your release conditions or failing to appear for your court dates would result in the loss of any bond that you post. A warrant would issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to advise you about this morning. If you have no questions for me, feel free to step to your left. Officer will give you your paperwork.
Thank you, Your Honor.
Ms. Santa Cruz, will you please come to the podium? And Mr. Shepard, if you'll please have a seat in the chair. Good morning, ma'am. Will you please state your first and last name and your date of birth?
Maria Santa Cruz, September 3rd, 1974.
You are here today because you have a warrant out of West Mesa Justice Court. I believe you have 2 warrants for failing to appear for a court date, and 2 direct complaints were filed. So first going to address your direct complaints that were filed. The first one, you were charged with possession of a narcotic drug, a Class 4 felony, and the second one is possession of drug paraphernalia, a Class 6 felony. And the date of those alleged offenses is May 23rd of 2024. I appointed an attorney to represent you in that matter. On your second direct complaint, you were charged with 1 count of possession of a narcotic drug, a Class 4 felony, possession of drug paraphernalia, a Class 6 felony, and 1 count of taking prohibited articles into jail, a Class 5 felony. Date of those alleged offenses is May 6, 2024, and I appointed an attorney to represent you in that matter as well. You will have a status conference on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. Each of those direct complaints had a secured appearance bond in the amount of $250. Then, as to your warrants for failing to appear for your court dates, an attorney was already appointed to represent you in those matters. You have a status conference hearing on September 10th at 8:30, and that warrant has a secured appearance bond in the amount of $4,500. The second warrant for failing to appear has a status conference hearing on September 10th at 8:30, and that warrant had a secured appearance bond in the amount of $1,000. Then, as to your warrant out of West Mesa Justice Court, I did appoint an attorney to represent you in that matter. You have an arraignment hearing on September 9th at 8:30, and you have a secured appearance bond in the amount of $50. If you are able to post your bond, and your total bond between the 3 cases is $6,050. If you are able to post bond, you must appear for all of your court dates, and you must comply with all of your release conditions. Failing to do so would result in the loss of any bond that you post. Warrants would again issue for your arrest, and additional bond would be imposed. This takes care of everything that I needed to talk to you about this morning. If you have no questions for me, feel free to step to your left. Officer will give you your paperwork. Thank you.
Just have a seat, we'll grab you. You're going to stay right here in the second row closest to the door.
Mr. Shepard, will you please come to the podium? And Mr. Jimenez, will you please have a seat in the chair? Hello, sir. Can you please state your first and last name and your date of birth?
Devin Lee Shepard,
And your date of birth?
August 31st, 1994.
You are here today because you have a warrant out of Verde Valley Justice Court. I did appoint an attorney to represent you. You do have an arraignment hearing on September 9th at 8:30. Your warrant had a secured appearance bond in the amount of $1,500. If you are able to post bond, you must appear for your court date. If you fail to appear for your court date, that would result in the loss of any bond that you post. Another warrant would issue for your arrest, and additional bond could be imposed. This takes care of everything that I needed to talk to you about this morning. If you have no questions for me, if you will please step to your left, officer will give you your paperwork. Thank you.
Yes, ma'am.
Mr. Jimenez, will you please come to the podium? And Ms. April Villarreal, if you'll please have a seat in the chair. Morning, sir. Can you please state your first and last name and your date of birth?
Federico Jimenez, 8/16/72.
You are here today on a new case. You were charged with 1 count of assault with intent to injure, a Class 1 misdemeanor, and 1 count of disorderly conduct involving fighting, a Class 1 misdemeanor. I did find probable cause, and I did appoint an attorney to represent you in this matter. You'll have an arraignment hearing on September 9th at 9 a.m. You have a cash-only bond in the amount of $500. If you are able to post bond, you cannot return to the scene of the alleged crime. You cannot initiate any contact with the alleged victim. You cannot possess any weapons. If there are any orders of protection or orders against harassment that have been issued, you must comply with those orders. You cannot reside at the same location as the alleged victim. You are permitted one civil standby with local law enforcement to assist you in collecting your essential belongings. If you violate the no victim contact order in this case, you could be charged with aggravated harassment, which is a Class 6 felony. Failure to comply with your release conditions or failing to appear for your court date will result in the loss of any bond that you post. A warrant will issue for your arrest and additional bond would be imposed. This takes care of everything that I needed to talk to you about this morning. If you have no questions for me, if you will step to your left, officer will give you your paperwork.
No question.
Okay, you'll step to your left, officer will give you your paperwork. Ms. Villarreal, will you please come to the podium, and Mr. Smith-Lipsy, if you'll please have a seat in the chair. Good morning. Can you please state your first last name and your date of birth?
Hi, my name is April Sabrina Villarreal, 5690.
You are here today because you have a probation violation warrant. I did appoint an attorney to represent you in this matter. You have a probation revocation possible disposition hearing on September 11th at 8:30. Your warrant had a secured appearance bond in the amount of $100. If you are able to post bond, you must appear for your court date. If you fail to appear for your court date, that would result in the loss of any bond that you post. Another warrant would issue for your arrest, and additional bond could be imposed. This takes care of everything that I needed to talk to you about today. If you have no questions for me, feel please step to your left. Officer will give you your paperwork.
Okay.
Yes.
Mr. Smith-Lipsy, if you'll please come to the podium, and Ms. Yvette Gonzalez, if you'll please have a seat in the chair. Good morning, sir. Can you please state your first last name and your date of birth?
Armani Smith-Lipsy, March 23rd, 2007.
You are here today on a new case. You were charged with 1 count of shoplifting by concealment, a Class 1 misdemeanor. I did find probable cause as to this offense. Due to the nature of the charge, you're not entitled to court-appointed counsel. You will have an arraignment hearing on September 24th at 1 p.m. I am going to release you on your own recognizance today. You do have to promise to appear for your court date. Do you promise to appear for your court date?
I promise.
You cannot return to the scene of the alleged crime. Failure to comply with your release conditions or failing to appear for your court date would result in a warrant issuing for your arrest, and a bond will be imposed. Do you understand?
Yes, ma'am.
Okay, if you'll step to your left, officer will give you your paperwork. Yes?
Will I have like a paper saying the date I have to come back?
Yes, the officer is going to give you your paperwork that has the date, the location, and the time of your court date.
Okay, thank you.
Mm-hmm. Ms. Gonzalez, will you please come to the podium? And Ms. Moreno, Becky Moreno, if you'll please have a seat in the chair. Good morning, ma'am. Will you please state your first and last name and your date of birth?
Yes, Yvette Carmen Gonzalez, 102048.
You were here today because a direct complaint was filed where you were charged with possession of narcotic drugs, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. The date of the alleged offense is April 7th, 2025, and I did appoint an attorney to represent you. I was trying to look over your case file. Were you in custody for something?
I'm in custody right now. I still have, I believe 64 days.
Okay, so I'm gonna have to change your release order because I couldn't see what was happening with you.
Okay, that's probably why.
Yeah, so, and the reason why I'm just gonna place a little bit of a bond on you is that while you're in custody, you will get transported to that hearing so that a warrant won't issue for your arrest, okay?
Okay, that's fine.
So, your actual court date is going to be, September 10th at 8:30, and the preliminary hearing will be September 12th at 8:30. If you will please just go ahead and have a seat. I'm going to get the paperwork out to you. I just need to make some corrections really quick, okay?
Okay. And then I'll be done, right?
Yeah,
okay.
So you can just go ahead and have a seat. We'll bring the corrected.
Thank you very much.
Okay, just fix that. Thank you. Ms. Moreno, will you please come to the podium? And Mr. Chavez, if you'll please have a seat in the chair.
Good morning.
Good morning, ma'am. Can you please state your first and last name and your date of birth?
Becky Moreno, 10/23/1967.
You are here today, this morning, on 3 matters. You have 2 warrants out of Goodyear Municipal Court, and you have 1 new case. On your new case, you were charged with 1 count of driving with a license that is suspended, revoked, or canceled, a Class 1 misdemeanor. I did find probable cause as to that offense. You are not entitled to, due to the nature of the charge, you're not entitled to court-appointed counsel. You will have an arraignment hearing on September 23rd at 2 p.m. Then, as to your warrants, again, you're not entitled to court-appointed counsel on those matters. You will have an arraignment hearing on September 24th on both of the warrants, September 24th at 1 p.m. As to all 3 of your matters, I am going to release you on your own recognizance. You do have to promise to appear for your court date.
I do.
So I will let you know that I'm giving you an opportunity to take care of what you need to take care of. The recommended bond on each of your warrants, I believe, was one of them, the recommended bond was $500. On both of them, the recommended bond is $500. So if you do not appear for your court date, at a minimum, you're going to be looking at about $1,000 of bond. I will also say this, it looks like each one of these offenses all stems from you driving without a license or driving with a license that is suspended. You probably need to take care of that, or you're going to keep ending up in spending time in jail.
I know.
Okay? So I believe that takes care of everything that I have to talk to you about. If you have no questions for me, if you'll step to your left, officer will give you
But
all.
I'll get out.
I'm releasing you on your own recognizance.
Thank you so much. Thank you.
Mr. Chavez, will you please come to the podium?
What's your name?
Sir, can you please state your first and last name and your date of birth?
Marcos Chavez, September 30th, 1991.
You are here today on a new case. You were charged with 1 count of driving with a license that is suspended, revoked, or canceled, a Class 1 misdemeanor. I did find probable cause as to that offense. Due to the nature of the charge, you're not entitled to court-appointed counsel. You will have an arraignment hearing on September 18th at 8:30. I am inclined to release you on your own recognizance. You do have to promise to appear for your court date. Do you promise to appear for your court date?
Yes.
If you fail to appear for your court date, a warrant will issue for your arrest and a bond will be imposed. This takes care of everything that I needed to talk to you about. If you have no questions for me, if you'll please step to your left, officer will give you your paperwork.
So, they slammed the door. I couldn't hear exactly. You said I'm getting a order release?
Yes, I'm releasing.
All right. Thank you, Your Honor.
Did you clear,
Officer Victor, we need to clear the courtroom.
Yes, ma'am. Yes, ma'am.
no problem, is clear for the study again?
Yes.
Yes, okay.
All right, so everybody just listen up to her. Okay, listen up. You have to see the show right there.
He can come in now.
All right, go ahead and come in. And let's talk in a second.
Sir, can you please state your first and last name and your date of birth?
Bobby Newton, 7/29/61.
You were here today on a new case. You were charged with five counts of aggravated assault, a Class 2 felony, 1 count of criminal damage, a Class 5 felony, 6 counts of endangerment, a Class 6 felony, and 1 count of disobeying or resisting a mandate or order of the court, a Class 1 misdemeanor. I did find probable cause as to all of these offenses. I did appoint an attorney to represent you in this matter. You have a status conference hearing on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. You have a secured appearance bond in the amount of $75,000. If you are able to post bond, you'll be released to pretrial services on electronic monitoring. You cannot return to the scene of the alleged crime.
You said 75,000?
75,000 secured appearance bond.
How do you go about paying that, miss?
Sir,
Okay.
at the beginning of the hearing, I asked you to please let me advise you of everything and to not interrupt.
All right, I'm sorry.
You cannot return to the scene of the alleged crime. You cannot have any contact with the alleged victims. You cannot possess any weapons. You must comply with the order of protection that is in place, and if there's an order against harassment that is issued, you must comply with the terms of that. You cannot reside at the same location as the alleged victims, and that would be all of the victims. You are permitted one local civil standby with local law enforcement to assist you in collecting your essential belongings. If you violate the no victim contact order in this case, you could be charged with aggravated harassment, which is a Class 6 felony. Failure to comply with your release conditions or failing to appear for your court dates would result in the loss of any bond that you post, and a warrant would issue for your arrest, and additional bond would be imposed. As for your question about posting bond, there is information back in holding. The officers will direct you to that on who you can contact as far as trying to obtain bond.
Okay, well, I'm trying to understand it, miss, because they only give you so much information, but if I can get it from a judge, then I would have better understanding.
I don't have anything to do with the posting of bond. That goes through the sheriff.
But I'm saying, you saying that I have to post a bond to get out? Is that what you're telling me?
I've told you that now twice. And
Okay.
told you 3 times.
So
you have a secured appearance bond in the amount of $75,000. Secured appearance bond means 10% plus collateral. So you have to pay $7,500 and be able to provide some type of collateral to a bail bonding agency in order to secure your release.
Okay. 75. Okay, I'm just trying to have understanding so when I call my family, I'll know.
I want you to have an understanding too, because I'm very concerned about what's happened here, the nature of the offense, and that there were children involved.
Yes, it was.
And we're not going to talk about it anymore. I'm just letting you know what my concern is, and this is why I issued the bond that I've issued and why I am expressing to you sternly that you must comply with these release conditions, because the alleged behavior for which I found probable cause on was very dangerous and resulting in injuries.
Well, there's nothing that I've done, Your Honor.
Sir, I made a probable cause finding. Do you want to know what I reviewed?
Yes, ma'am.
According to the probable cause statement, you were following your wife or ex-wife even though there was an order of protection. I found that fact to be true. I made a probable cause finding that that's likely to be true. I made a probable cause finding that as your wife was fleeing from you, that you crashed into her car, the rear of her car, multiple times with your children in the car. I made a probable cause. Okay, so we're done here. You may go ahead and have a seat.
No, ma'am,
Go
miss.
ahead.
I mean, I'm
Officer,
listening
give
to
me
you, but it's ineffective is what it's saying is I've never crashed into no car.
Yeah, come on, sir.
I'm coming, sir.
She's
I'm
done
coming.
speaking. Let's go.
I'm trying to get understanding.
She's done.
with the
Let's go.
judge. If I can't get understanding with the judge, then I'm not gonna know what am I doing.
Keep going. We're out of
That's
the
all
room
I'm
now.
trying to do, Your
Hey, we're
Honor.
done talking. Come on.
I'm just trying to get understanding.
Have a seat right there.
Mr. Baker?
Have a seat. Before I have some more officers, and we're gonna have to escort you to your cell. All right, come on, sir. Mr. Baker, sir. Thank you. All right, go to the podium, sir.
Okay, and then if you reach out for interpreter. Okay. Mr. Baker, can you please state your first and last name and your date of birth?
Brandon Baker, 4491.
You are here today because the grand jury charged you with failing to register as a sex offender, a Class 4 felony. The date of this alleged offense is January 30th, 2025. I did appoint an attorney to represent you in this matter. You do have an arraignment hearing on September 11th at 8:30. The grand jury bond had a secured appearance bond in the amount of $1,000. If you're able to post bond, you must comply with your release conditions as well as appear for your court date. If you fail to appear for your court date or comply with release conditions, you will lose the bond that you posted, another warrant would issue for your arrest and additional bond could be imposed. This takes care of everything that I needed to advise you about this morning. If you have no questions for me, if you will please step to your left, the officer will give you your paperwork. Thank you.
Thank you.
Mr. Campos Cortez, will you please come to the podium?
Señor Campos Cortés, por favor pase al podio.
Sir, can you please state your first and last name and your date of birth?
Señor, por favor, ¿puede decirme su primer nombre y apellido y su fecha de nacimiento?
Aldair Campos, del 5 de febrero de 1995.
Aldair Campos, February 5th of 1995.
And Ms. Gaunt?
Señora Gaunt.
Your Honor, Brooke Gaunt on behalf of the state.
Su señoría, soy Brooke Gaunt, represento al Estado.
Sir, you are here today on a new case.
Señor, está usted aquí en un nuevo caso.
You were charged with 1 count of sexual assault, a Class 2 felony.
Usted acusado de cometer agresión sexual, un delito de categoría 2.
1 count of sexual conduct with a minor, a Class 2 felony.
Un punto acusatorio de conducta sexual deshonesta con un menor impúber, un delito categoría 2.
And 1 count of molestation of a child, a Class 2 felony.
Y un punto acusatorio de abuso deshonesto contra un menor impúber, un delito categoría 2.
I did find probable cause as to all 3 charges.
He determinado que existe un motivo para vincularlo a estas acusaciones.
I did appoint an attorney to represent you in this matter.
En esta causa he nombrado un abogado para que le represente.
You have a status conference hearing on September 10th at 8:30.
Tiene una audiencia, una consulta de actualización septiembre 10 a las 8:30.
You do have a preliminary hearing on September 12th at 8:30.
Y una audiencia preliminar septiembre 12 a las 8:30.
Ms. Gaunt, I did review your recommendations. Are you wanting to make a record at this time?
Señora Gaunt, ya leí sus recomendaciones. ¿Quiere usted asentar algo en actas a este punto?
No entendí eso.
Ms. Gaunt, we can't hear you.
I didn't understand that. Señora Gaunt, no le oímos.
Can you hear me now, Your Honor?
Yes, yes.
I apologize. The state is asking for a $250,000 cash-only bond.
Sí, su señoría, mis disculpas. El Estado está pidiendo que se fije una fianza en la cantidad de $250,000 en efectivo solamente.
If Mr. Campos is able to post that bond, we'd ask for electronic monitoring as is required by statute and no contact with any minors.
Si es que el señor Campos logra depositar esta fianza, le pedimos de que lo ponga bajo el monitoreo electrónico y que no vaya a tener ningún tipo de contacto con ningún menor de edad.
These requests are based on the nature of the charges. Mr. Campos allegedly engaged in oral sexual contact with the 12-year-old victim on multiple occasions.
Y esto se debe al carácter de las acusaciones en su contra. El señor Campos se involucró con contacto sexual oral con un menor de 12 años en varias ocasiones.
Our understanding is that Mr. Campos has a fugitive of justice probation warrant from the state of Texas.
Tenemos entendido que el señor Campos tiene una orden de detención por ser un prófugo de la justicia. I'm so sorry, the interpreter. From what state was that?
Texas.
Thank you. Del estado de Texas.
He is a Mexican national believed to lack legal status in the United States.
Él es un ciudadano mexicano y se cree que no tiene la condición migratoria legal para estar en los Estados Unidos.
We are concerned, given the nature of these charges, that he is a danger to the community and an extreme flight risk, given the basis that I've already stated, and his possible mandatory lengthy prison sentence if convicted.
Al Estado le preocupa de que él es un peligro para la comunidad y también que es un peligro extremo de la fuga, ya que las circunstancias y las condiciones que he mencionado, incluyendo el hecho de que él está expuesto a pasar un periodo extenso en prisión.
Thank you.
Gracias.
I do need to also note that Mr. Campos Cortez is here for a fugitive of justice matter as well, which we will address after this matter.
Y también quiero indicar en las actas de que el señor Campos está aquí debido a una cuestión referente a ser el prófugo de la justicia también, y voy a hablar de eso en un momento.
Mr. Campos Cortez, you will have a cash-only bond in the amount of $250,000. If you are able to post bond, you will be released to pretrial services on electronic monitoring.
Señor Campos, estoy fijando una fianza en su caso en la cantidad de $250,000 en efectivo solamente, y si usted llega a depositar esta fianza, estará bajo el monitoreo electrónico del Servicio de Control de Procesados.
You cannot return to the scene of the alleged crime.
No puede usted regresar al lugar del presunto delito.
You cannot have any contact with the alleged victim.
No puede tener ningún tipo de contacto con la presunta víctima.
You cannot have contact with any minors.
No puede tener ningún tipo de contacto con ningún menor.
And you are prohibited from possessing any weapons.
Y se le prohíbe estar en posesión de ningún tipo de arma.
Failure to comply with your release conditions
El no cumplir con estas medidas cautelares,
or failing to appear for your court date
pues no comparecer a sus audiencias,
would result in the loss of any bond that you post.
resultará en la pérdida de cualquier fianza que usted haya depositado.
A warrant would issue for your arrest.
Se emitiría una orden de detención en su contra
An additional bond would be imposed.
y se impondría otra fianza adicional.
I am next going to address your fugitive of justice matter. Ms. Gaunt, I'm not sure if you wanted to remain for this matter as well. If you'd like to be excused, you may be.
Señora Gaunt, no voy a tratar la parte del prófugo de justicia si usted quiere continuar en esta causa, pero si no, puede desconectarse.
Sir, you have a warrant for your arrest from the state of Texas.
Señora, hay una orden de detención en su contra del estado de Texas.
This makes you a fugitive of justice.
Eso resulta ser que usted es un prófugo de la justicia.
As a fugitive of justice, you have a right to an extradition hearing.
Como un prófugo de la justicia, usted tiene el derecho a una audiencia referente a su extradición.
Because your warrant indicates that your warrant is a violation of probation,
Ya que la orden de detención en su contra indica de que se debe a que usted infringió su régimen a prueba,
you are not entitled to bond.
no tiene el derecho a una fianza.
You do have the right to hire an attorney at your own expense.
Usted tiene el derecho de contratar a su propio abogado y pagar de su propio bolsillo.
One would not be appointed to you because this is a civil matter rather than criminal in nature.
Y no se le nombraría uno, ya que esa es una causa de lo civil y no de lo penal.
Extradition requires a governor's warrant to be signed by the governor of Arizona and the governor of Texas.
La extradición requiere de que se firme una orden de extradición por los gobernadores de Arizona y el gobernador de Texas.
This process can take between 60 and 90 days.
Este proceso puede llevar de 60 a 90 días.
You do have the right to waive an extradition hearing.
Usted tiene el derecho a renunciar a la audiencia de extradición.
Again, you would not be entitled to bond.
Otra vez, no tendría usted el derecho a fianza.
Texas would have 30 days from tomorrow to pick you up if you had no local charges pending.
Si usted no tiene acusaciones pendientes localmente, Texas tiene 30 días para venir por usted, empezando el día de mañana.
Because you have local charges pending,
Pero ya que tiene usted acusaciones locales pendientes,
the 30 days would not begin until those matters were resolved.
los 30 días no empezarían sino hasta que esas causas se resuelvan.
I believe that you did have an opportunity to review the plastic documents that advised you about this process.
Y sí creo que usted tuvo la oportunidad de repasar el documento que está laminado referente a este proceso.
Do you know how you would like to proceed?
¿Sabe usted de qué manera quiere proceder hoy?
No, todavía no sé.
No, I don't know yet.
So at this point, then I will indicate that you are not going to waive your rights today.
A este punto, entonces indicaré que no renunciará usted a ese derecho.
You will have an initial fugitive from justice hearing on September 15th at 1:30.
Tendrá usted una audiencia inicial referente a ser un prófugo de la justicia, septiembre 15 a las 8:30.
This takes care of everything that I needed to talk to you about this morning.
Y eso es todo lo que tenía que comunicar esta mañana.
If you do not have any questions for me,
Si no tiene preguntas para mí,
the officer is going to give you your paperwork.
el oficial le va a entregar su papel.
Okay. Gracias.
Okay, thank
Mr.
you.
Parra, thank you so much. You may be excused.
Thank you.
So Ann Gerardo, her date of birth is March 5th, 1991. She's not physically present in court because due to her behavior. She is here on a direct complaint where she was charged with one count of transporting or selling a dangerous drug, a Class 2 felony, alleged to have occurred on May 28th of this year. I did appoint an attorney to represent her in this matter. She has a status conference hearing on September 10th at 8:30 and a preliminary hearing on September 12th at 8:30. The direct complaint had a secured appearance bond in the amount of $1,000. Ms. Gerardo will be advised that if she fails to comply with her release conditions or if she fails to appear for her court dates, any bond that she posed will be forfeited. A warrant would issue for her arrest and additional bond would be imposed. After I meet with Ms. Gerardo, if any changes are needed, I will do so either on the record or in writing. This takes care of everything. This concludes our 8 a.m. initial appearance calendar, and we stand in recess until 11 a.m.
All right. All right, thank you. Please be seated. Have a seat. Okay, thank you very much. All right, can the interpreter hear me?
Good morning, Your Honor. Yes.
All right, good morning. Okay, this is the 11 a.m. initial appearance calendar for September 4th, 2025.
Esta es la lista de comparecencias iniciales de las 11 de la mañana de septiembre 4, 2025.
Court's orders for the taking of fingerprints and DNA samples made on the first calendar of the month will also apply to these hearings.
La orden referente a la toma de huellas dactilares y muestras de ADN emitidas durante la primera lista de comparecencias de este mes también aplican a las causas de hoy.
Mr. Berriesa Martinez, will you please come to the podium? You will be first.
Señor Berriesa Martínez, pase al podio. Empezaremos con usted.
Good morning, sir. May I please have your full name and your date of birth?
Buenos días, señor. ¿Me puede, por favor, dar su nombre completo y su fecha de nacimiento?
Ok, mi nombre es Roberto Alejandro Berriesa Martínez y mi fecha de nacimiento es el 24 de abril de 1996.
Okay, my name is Roberto Alejandro Berriesa Martínez, and my date of birth is 24th of April of 1990.
All right, thank you. You have been arrested on the following allegations. Can you hear me? We lost the interpreter, I think.
Yes, Your Honor, I can hear you now.
Okay, you've been arrested on the following allegations.
Usted ha sido arrestado bajo las siguientes acusaciones.
2 counts of armed robbery as Class 2 felonies.
2 puntos acusatorios de robo a mano armada, delitos categoría 2.
Though now I've just realized the police actually only describe one. So for purposes of this hearing only, I'm finding probable cause on one of those armed robbery allegations, not the other one.
Bueno, me doy cuenta que la policía solamente indica que es uno. Sin embargo, estoy determinando que existe un motivo fundado a una de las acusaciones solamente.
Based on what they've alleged, I think that may actually just be an error on their part.
En base de lo que ellos afirman, creo que simplemente es un error por parte de ellos.
But you can go over what might be formally charged against you with your lawyer next week.
Pero la semana entrante podrá hablar usted con su abogado referente a lo que formalmente puedan ser las acusaciones.
All right, you've also been arrested on one allegation of kidnapping, which the court finds probable cause for as a Class 2 felony.
Ok, también usted se encuentra acusado de secuestro, lo cual la jueza ha determinado que existe un motivo fundado para vincularlo a esta acusación. También es un delito categoría 2.
Aggravated assault with a deadly weapon or dangerous instrument, which is a Class 3 felony.
Agresión y agravante con un arma mortífera. Este es un delito categoría 3.
Possession of dangerous drugs, which is a Class 4 felony.
Posesión de droga nociva, un delito categoría 4.
And 1 count of possession of drug paraphernalia, a Class 6 felony.
Y un punto acusatorio de posesión de parafernalia de droga, un delito categoría 6.
There is probable cause for all of those crimes.
Existe un motivo fundado para vincularlo a todos estos ilícitos.
There is not, for purposes of today's hearing only, probable cause for the marijuana possession and the second allegation of drug paraphernalia possession.
En este caso, a este punto, no existe un motivo fundado para vincularlo a la acusación de estar en posesión de marihuana y por el segundo punto acusatorio de posesión de parafernalia de droga.
And that is because the police did not allege that you had more than the legally permitted personal use amount.
Y eso se debe al hecho de que la policía no afirmó de que usted tuviese más de lo que se le permite tener en posesión, la cantidad de posesión permitida.
Don't print it yet. Your next court date is a status conference, September 10th at 8:30 in the morning in the Downtown Superior Court.
Su siguiente audiencia es una consulta de actualización el 10 de septiembre a las 8:30. Ese es el Tribunal Superior del Centro de la Ciudad de Phoenix.
Your preliminary hearing will be September 12th at 8:30 in the morning in the same court.
Y su audiencia preliminar será el 12 de septiembre a las 8:30 en el mismo tribunal.
Based on what's been alleged against you, the court is going to follow the recommendation of the prosecution in this case.
En base de las afirmaciones en su contra, la juez seguirá las recomendaciones de la fiscalía en este caso.
Because these are violent offenses and there does appear to be a strong weight of evidence against you.
Porque estos son ilícitos violentos y parece que existe una cantidad considerable o una cantidad fuerte de indicios en su contra.
And you have significant ties to a foreign country.
Usted tiene vínculos importantes y considerables con un país extranjero.
So the court is very concerned that you may be dangerous and that you may not appear for trial.
La juez tiene mucha inquietud de que usted sea una persona peligrosa y de que no vaya usted a comparecer a su proceso judicial.
For these reasons, bond is set in your case in the amount of $50,000. It is cash only.
Y por esas razones se fija una fianza en la cantidad de $50,000 en su caso y solamente en efectivo.
If you deposit that with the court, you will be released, and be sure to comply with your remaining release conditions.
Si es que usted deposita esta fianza, se le pondrá en libertad y si se le pone en libertad, asegúrese de obedecer las medidas cautelares.
You may not go to the scene of the alleged crimes nor have any contact with the alleged victim.
No puede usted ir al lugar del presunto delito, tampoco tener ningún tipo de contacto con las presuntas víctimas.
No contact with any co-defendant.
No tenga ningún tipo de contacto con ningún coacusado.
No weapons and no drugs without a valid prescription.
No vaya a estar en posesión de ningún arma, tampoco de ningún tipo de medicamento o droga sin tener una receta válida.
And you may not leave the state of Arizona without the permission of the court.
Y no podrá usted salir del estado de Arizona sin el permiso de un tribunal.
Everything I've just told you is on your paperwork. If you step to your left, the officer has your copy. Thank you.
Todo lo que le he dicho está en sus papeles. Si pasa usted a la izquierda, el oficial le entregará su copia. Gracias.
Thank you. All right. And if the interpreter could make a general call, that would be great.
Yes, sir. ¿Hay alguien más en la sala que necesita asistencia en español para esta diligencia? Levante su mano, por favor.
Okay. Again, I see no hands. Officer, can you just take a peek back there and make sure there's no hands?
Yeah.
Okay. I thought we had one who I was like on the bubble. Do we have one? Is it? Oh, for which? Oh, just the assistance? Okay. All right, we're good to go for the interpreter. Thank you so much. You're welcome to disconnect.
Thank you.
Okay, thanks. All right, then I do see that I have counsel in the hearing. Counsel, I had been planning to do your client's hearing at the end of the docket for reasons you may be aware of. Are you asking the court to?
No, that's
Okay,
fine, Your Honor. I just wanted to make sure I logged in and I didn't miss kind of the timing. Sometimes it's quick, sometimes it's longer, so.
Well, it's more, I don't want to overstate it, but, okay.
I understand why we would go last. I just wanted to log in so that I was, ready for when it is our turn.
Fair, okay. Okay, thanks. Well, then definitely just wait in the back of the virtual courtroom. It's going to be a while. Okay,
Thank you,
thanks.
Judge.
All right. Let's see, Mr. Fidel Velarde, will you come to the podium, please? Brian Fidel Velarde? After that will be Ashley LaFour, if you please go to the podium. Mr. Fidel, right here to the podium, please. All right, sir, may I have your full name and your date of birth, please?
It's Axel Fidel Velarde, January 30th, 2004.
Well, that's kind of different. All righty, just a second. Tell me your name again.
Axel Fidel Velarde.
Axel, A-X-E-L?
A-X-E-L, F-A-D-E-L, and then V-E-L-A-R-D-E.
V-E, no hyphen?
No, yeah. V-E-L-A-R-D.
Okay, and what did you tell me your date of birth was?
January 30th, 2004.
Okay. All right. All right, sir, and I think on that name difference, let's reprint, okay? All right, sir. Well, it's already listed as an AKA. One second. I'm going to look at your booking paperwork. As far as you know, what does your driver's license say? Or state ID?
Oh, my ID?
Yeah.
I don't got a driver's license, but...
What's your ID say for your first name?
What do you mean? Oh, like my Axel?
Your first
Antonio?
name, yeah. What's on your birth certificate?
What do you mean? Like my middle name?
When you were born, why is the name Brian all over your criminal history?
No, that's what they told me too. I don't know why, but they got it confused.
Okay.
And they said they already talked to you.
Because you got a lot of juvenile history. You have been arrested multiple times since turning 18, and
yeah, that's what I was telling them. I was like, why is my brother's name in there if I got my social security number?
So there is a Brian.
Yeah, that's my brother.
Well,
Brian.
That's not good. All right, what I'm going to do is, well, now there's a lot of, because right now this shows as, I don't know if your brother's been using your name too.
Yeah.
We see that sometimes. Siblings start doing that, and sometimes it works out badly for them. So, listen, looks like you have Brian listed as an alias. I bet he has Axel listed as an alias. So I'm gonna reprint the paperwork so that it says Axel at the top, because you're telling me that's your true name and Brian is your brother.
Yeah, that's my
You
brother.
need to talk to your lawyer about making sure that the court and the prosecutor's office is clear on who you are and what criminal history is yours versus your brother's. Because at this point, it sounds like they're starting to get mixed up. Which is going to end badly for both of you. I see people who've been doing that for 20 years, and they like to complain that they got arrested on their sibling's warrant, and then they turn around and do it to their sibling, and frankly, it's just a bad idea for everybody. But or they'll lie and use the sibling's name thinking they won't get arrested, but it turns out the sibling has a warrant. And so I certainly don't recommend ever doing that. I'm not saying that you are, but you're telling me you're Axel. We're going to go forward as Axel. You've been booked in for 2 counts of aggravated assault with a deadly weapon or dangerous instrument. Those are class 3 felonies, and there is probable cause for them. I am appointing a lawyer for you. I'm scheduling a status conference September 10th, which is 1 week from yesterday, at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing September 12th at 8:30 in the morning. Based on what's been alleged against you, what I understand to be your criminal history associated with your fingerprints, bond is set in the amount of $25,000. It is secured, and I apologize. I intended to do an ankle monitor in this case. We're going to reprint one more time. If you post that, you're going to come out on an ankle monitor to prove that you are not living where this happened. You may not have any contact with the alleged victims. I know they're family members. You may not respond to any contact from them. What you can do is a civil standby with law enforcement to collect belongings after you post bond and get out. No weapons, no drugs, no alcohol. If you get served with an order of protection, comply with that as well. All right, here comes the newest paperwork, officer. This is the second reprint on this guy, so we need to get one more, because I forgot the ankle monitor for him. And you give him an envelope if you would. Okay. All right, we're going to get you your proper paperwork, Mr. Fidel, and then you can step out to your left.
I have a question.
What's your
So
question?
on September 12th, we're gonna... 10th, we're gonna be reuniting.
You're going to be what?
Reuniting again?
Yeah, I'm not your trial judge. It's going to be downtown.
Oh, downtown?
Right. This is just your initial appearance. And so downtown, you do have 2 court dates. One's on the 10th, one's on the 12th.
Okay.
And so you'll see your lawyer on the 10th, which is 6 days from now. All right.
Okay.
If you step to your left, you get your paperwork.
Okay.
All right. Thank you. All right, Ms. LaFleur, and then Kira or Kyra Harris, will you go to the chair, please? Hello, ma'am. May I have your full name and your date of birth?
Ashley Michelle LaFleur, 10/25/1989.
All right, thank you. You're here on one new case and a warrant. In the new case, you were arrested for theft of a means of transportation. It's a Class 3 felony, and there is probable cause for it. I am appointing a lawyer for you, setting a next court date of this Wednesday, September 10th at 8:30 in the morning in the Downtown Superior Court, with a preliminary hearing scheduled Friday, September 12th at 8:30 in the same court. That address will be on your paperwork. You're also here on a failure to appear warrant. There was a non-witness violation hearing scheduled in your felony probation case on May 16th of 2024. You were not there, and a warrant was issued for your arrest. You already have a lawyer in that case. You should end up with the same lawyer for both cases. The probation cases, pardon me, your court date is 1 week from today, which is September 11th at 8:30 in the morning. That is a non-witness violation hearing and possible disposition hearing. In the new case, bail is set at $2,000 secured. In the new case, it is $1,000 secured for $3,000 total. If you bond out, comply with all of your written conditions, especially do not go to the scene of the alleged auto theft, absolutely no contact with the alleged victim in that case. If you step to your left, the officer will give you your paperwork.
There's no way you can, ma'am, can I ask a question?
Yes.
Is there any way I could do an ankle monitor at all?
No, ma'am, this court has no intention, this court would not trust you on an ankle monitor.
All right, cool. Right on.
All right, Ms. Harris, Kira Harris or Kyra Harris, and then Calvin Williams, will you go to the chair? Hello, ma'am, may I have your full name and your date of birth, please?
My name is Kyra Harris, April 6, 2001.
All right, thanks. You are here on a bench warrant for failing to appear at a status conference in a case in which you have been charged with unlawful flight from a law enforcement vehicle, a Class 5 felony, driving on a suspended license, a Class 1. Officer, can you ask them to be quiet? Yes. I need quiet out there. It's very loud in here. Thank you. Sorry, ma'am. Driving on a suspended license, a Class 1 misdemeanor. Thank you, officer. And possession of alcohol in a motor vehicle, that's a Class 2 misdemeanor. This warrant was issued August 14th out of a status conference in the Downtown Superior Court. You already have a lawyer in the case. Your next court date is this Wednesday, September 10th at 8:30 in the morning. That's at the court address on your paperwork. I believe you were there at least once. Your preliminary hearing will be September 12th at 8:30. I'm affirming the trial court's bond, which is $1,000 secured. If you post it, comply with all of your written conditions and do not miss your court dates. If you step to your left, I'll have your paperwork for you. Mr. Williams, Calvin Williams, please. And then Cheryl Lucas, will you go to the chair? Mr. Williams? Mr. Williams, all the way in, please. After that, Cheryl Lucas, you can go to the chair. Right here, sir. Hello, sir. Can I have your full name and your date of birth?
Calvin Jordan Williams, 62003. Sorry about that. Good morning.
I'm sorry?
Sorry about that. Good morning.
Nothing to be sorry about. All right, you're here on one warrant for failing to appear and one arrest warrant in an older case that has now been charged against you. I'm going to start with the failure to appear warrant. You are on probation for possession of drug paraphernalia, a Class 6 felony. There was a revocation arraignment scheduled August 15th of this year. You did not appear, and a warrant was issued for your arrest. Your next court date in probation court will be a revocation arraignment and possible disposition hearing 1 week from today, which is September 11th at 8:30 in the morning in the downtown probation court. Now, you've also been formally charged by the county attorney's office in a new criminal complaint. It was filed August 21st, and it charges you with possession or use of narcotic drugs back on March 26th of this year. It looks like this comes out of the Phoenix Police Department, but you'll get a copy of the charges and police reports from your lawyer. It's just one charge, narcotic drugs, and I am appointing a lawyer for you. So your next court date in the newly filed case will be this Wednesday, September 10th at 8:30. That's a status conference with a preliminary hearing September 12th at 8:30 in the same court. In the probation case, your bond is $750 secured. In the new case, it is $50 secured to make you eligible for credit for time in custody, because we would have released you in the absence of the probation case. So your total bond is $800 for the two cases. If you bond out, you must comply with your probation, so call them within 72 hours. You must appear for all of your court dates. You already FTA'd on one bond. You will lose this money as well. That money's been forfeited. So if you do it again, you'll forfeit more bond, and you should expect either to be held without bond at the next hearing that we see, or to have a far more substantial bond in the thousands if you do this again. If you step to your left, you're going to get a copy of your paperwork. Thank you.
I don't remember being
All right, Ms. Lucas? And then Robert Parker, we go to the chair. I need Cheryl Lucas. Is that you, ma'am? Okay. And then Robert Parker, we go to the chair. Hello, ma'am. Have you been able to hear me? Can you hear me?
I can now, yeah.
Okay, good. Will you tell me your full name and your date of birth?
My name is Cheryl Lucas, and I was born April 12th, 1962.
Okay, thanks. And officer, I'm just having a lot of trouble hearing. Maybe can you ask, see if they'll clear traffic? And it's not a lobby. It's the courtroom, and we can hear it echoes. It's much louder in here than you think. I need everybody to please be quiet. All right, everyone's trying to hear. Thank you. All right, I'm sorry, Ms. Lucas, you're here on one new case and a probation warrant. In your new case, you were arrested for dangerous drug possession, a class 4 felony. And I apologize. I need to edit number 2. That's the probation case. 1 second, ma'am. Okay. All right. I'm going to go back to your new case. What you're accused of from yesterday is possessing dangerous drugs, a class 4 felony, and drug paraphernalia, a class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. Your next court date is a status conference this Wednesday, September 10th at 8:30 in the morning, with a preliminary hearing September 12th at 8:30. Those are next week, and the court address will be on your paperwork. That's your new case. You are also here on a probation violation warrant. Back on April 19th of 2024, there was a petition to revoke your probation filed. It alleges that you violated terms 3, 4, 5, and 7. You will get a copy of that from your lawyer, and I am appointing a lawyer for you.
He wanted me to get rid of my dog.
Hold on, ma'am. I'm not done telling you things. Your probation court date is September 11th, also next week, 8:30 in the morning. That's a revocation arraignment and possible disposition hearing. In your probation case, you have a $750 secured appearance bond. In the new case, you have a $500 secured appearance bond. That is $1,250 total with written conditions. I'm not sure what you're telling me about your dog, but if your dog is alone at any location where it could die as a result, you need to call animal control and notify them, or you could be charged with felony animal cruelty.
How could I be charged with animal?
Is your dog alone and locked in a location?
I don't know.
Was your dog with you when you were arrested? Then your dog is not alone. All right, if you step to your left, you get a copy of your paperwork. Good luck. All right. Mr. Parker? And then Robert Goritsky, will you go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Robert David Parker, the second, July 18th, 1987.
All right, thanks. You're here on 2 probation warrants. You're on probation in 2 different cases. There were petitions to revoke your probation filed about a week ago, August 27th. They allege that you violated terms 3 and 5. You'll get copies of those from your lawyer. I am appointing a lawyer for you. Your next court date is 1 week from today, which is September 11th at 8:30 in the morning in the downtown Superior Court. Your bond in each of the 2 cases is $500 secured for $1,000 total. If you bond out, comply with all of your written conditions and call your PO within 72 hours of hitting the street. If you step to your left, you get a copy of your paperwork. All right, Mr. Goritsky? Robert Goritsky, and then Mark Conrad. Will you go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Robert Gritsky, November 29th, 1984.
November 29th?
Yes.
Okay, thanks. You're here on one new case? Are you able to hear me?
Yes.
Okay. And two probation cases. All right, in the new case, you were arrested for dangerous drug possession, a class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. Your next court date will be this Wednesday, September 10th at 8:30. It's a status conference. Then a preliminary hearing will be September 12th at 8:30. You're also here on two, I'll give it a second. Okay. You're on probation in two cases. There was a disposition hearing scheduled for you on August 22nd of this year. You were not there, and as you know, warrants were issued for your arrest. I say as you know because I saw the motions to quash. Oh, whoops.
Yeah.
Hang on, I made a typo. I said MTG is pending. It's MTQ, motion to quash. So I am not wanting that typo to go across the street. So I'm going to reprint both of these probation ones. Because that won't make any sense to anybody. MTQ is motion to quash. Okay. All right. That was filed. It was not granted. What the court did, as it often does, is it set a hearing, and it probably would have quashed them if you had showed up. But the hearing isn't until next week. In the meantime, you got caught on a new case and these warrants. So, in any event, you're going to go to probation court. Right now, it is scheduled as your disposition hearing, September 11th at 8:30 in the morning. But if these new charges also go forward, I'm sure they won't go to disposition next week because you need to resolve everything together. Talk to your lawyer about that on the 10th. All right, so in the probation cases, again, your court date is the 11th, which is 1 week from today, 8:30 in the morning. And I'm affirming the bond in both cases. It's $250 secured. So you have a $50 placeholder bond in the new case, because in the absence of those probation cases, we would have released you. Your total bond is $550. It is secured. If you bond out, comply with all of your written conditions, do not miss your court date. If you step to your left, you get a copy of your paperwork.
So I can't have pretrial services because I put in a motion to quash these warrants.
I know. That's the one and only reason I didn't raise your probation bond.
Okay.
The one and only reason. You you not only picked up a new charge, but the judge did not grant your motion to quash. Just because you filed it doesn't mean anything to that judge until you show up in court.
Yeah.
They do this a lot with people they don't trust. They're like, good for you for filing a motion, but the warrant is going to stay active until we see your face, and then they get popped on it. And so, and you also picked up new charges, so you don't get any sympathy for that. What you do get is I did not raise the bond in your probation case, which I otherwise would have because of the new case.
All right,
so
thank you.
If you step to your left, you get your paperwork. All right, Mr. Conrad? And then Kristen Chi, will you go to the chair? Where's Mr. Conrad? He's dressed out. He's probably about 60 years old. Mr. Mark Conrad. He's wearing orange.
He's on the way.
Okay, here he comes.
He's just really slow.
Oh, okay, no worries. Here you go, sir. Please take your time. I thought maybe you were asleep. Then we'll be Kristen Sheen. Hello, sir. May I have your full name and your date of birth, please?
Mark Allen Conrad, 261.
All right, thank you. You are here on a probation warrant. You are on felony probation, and back on July 17th of this year, there was a petition to revoke your probation filed. It alleges that you violated terms 3 and 5. You'll get a copy of it from your lawyer. I am appointing a lawyer for you. Your next court date will be a revocation arraignment and possible disposition hearing 1 week from today, which is September 11th at 8:30 in the morning in the downtown Superior Court. I'm affirming the probation judge's bond for you, which is $500 secured. If you bond out, comply with all of your written conditions. That includes calling your PO within 72 hours of hitting the street. If you step to your left, the officer will give you your paperwork. Thank you. All right, Ms. Chi, Kristen Chi. And then Emmett Dosella, we go to the chair. Hello, ma'am. May I have your full name and your date of birth, please?
Kristen Chi, 4591.
All right, thank you. You are here on 3 probation warrants. You're on probation in 3 separate felony cases. There were petitions to revoke filed in all 3 of your cases. Those petitions allege that you violated terms 3, 4, 5, and 15. You'll get copies of those from your lawyer, and I am appointing a lawyer for you in all 3 cases. Your next court date is September 11th at 8:30 in the morning. That's for all 3 cases. It's 1 week from today in the downtown probation court. That address will be on your paperwork.
Okay.
In all 3 of your cases, in each of them, your bond is $250 secured for $750 total. If you bond out, comply with all of your written conditions and call your probation officer within 72 hours of actual release. If you're a step to your left, you get a copy of that paperwork. Thank you. All right, Mr. Dosella. Where's Emmett? He's kind of a young guy, wearing red. He's probably about 20. Okay, here we go. Hi, sir. Come on in, Mr. Dosella. After that, Brian Johnson, we go to the chair right there at the podium, please. Hello, sir. Can I have your full name and your date of birth, please?
Emmett Gossa, June 8, 2003.
Okay, thanks. You're in 1 new case and 1 probation warrant. In your new case, you were arrested for possessing narcotic drugs, a class 4 felony, and drug paraphernalia, a drug paraphernalia, which is a class 6 felony. Oops. Okay, I'm just reprinting a lot this morning. I am appointing a lawyer for you. It got left as no decision on the lawyer. So I am going to appoint a lawyer for you in your new case. So we'll reprint that so it's clear. Mr. Dosla?
Yeah.
Okay, try to stay focused.
Yeah.
You have 2 cases. I'm giving you a lawyer for both. You have 3 court dates next week. In the new case, the new narcotics case, your court date is Wednesday, September 10th at 8:30, preliminary hearing Friday, September 12th. In the probation case, your court date is Thursday, September 11th at 8:30. In the probation case, your bond is $250. In the new case, it is $50. So that's $300 total. If you bond out, comply with all of your conditions, call your PO within 72 hours.
Right.
Everything is on your paperwork. We're going to get that reprinted and sent out to you. So if you go have a seat, the officer's going to bring it to you. Don't lose it. I doubt you're going to remember this hearing very well. So don't lose your paperwork. Everything I just told you is on it, okay?
All right.
Go ahead and step out to your left. Yeah, sorry, I had to fix that one to give him a lawyer. Yeah, he needs one new one for the new case, the PF. He needs a new PF one, officer. This guy? Dosala? Yeah. It's the PF that we need to trade out because he gets a lawyer. Thank you.
Okay.
Thank you. All right, Mr. Johnson. After that, Kashawn Crump Valencia. We go to the chair. Hello, sir. May I have your full name and your date of birth?
Brian Philip Johnson, November 29, 1986.
All right, thank you. You're here on a new case. You were arrested for narcotic drug possession, a class 4 felony, drug paraphernalia possession, a class 6 felony, and driving under the influence of drugs as a class 1 misdemeanor. Also, driving under the influence of alcohol, drugs, or a combination while impaired to the slightest degree, also a class 1 misdemeanor. There is probable cause for all of them. I'm not appointing a lawyer for you because you do not appear to financially qualify. You have the right to hire a lawyer at your own expense or to represent yourself. Okay. Your next court date is a status conference, September 18th, which is 2 weeks from now at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing September 22nd at 8:30 in the morning. You are not without criminal history. You do not appear to have prior felony convictions. You do have a prior DUI from 2018. This court has considered what's been alleged against you. It is my decision to release you to pretrial services with alcohol testing and monitoring. You will not drink alcohol. You will not use drugs, illegal drugs. While the case is pending, you will test to prove that. The court is deeply concerned about the allegation in this case of smoking fentanyl in a vehicle while driving and then passing out in an intersection. That tends to make other people die, that kind of behavior. It is incredibly dangerous. And there appears to be a strong weight of evidence that you did do this. I'm also deeply concerned because you say you work at a school, and if you're driving a car to school, there may be children in the parking lot. So right now, based on the totality of your criminal history, I'm not prohibiting you from driving. I thought about it. I'm not doing that yet. That's absolutely on the table for any other court, though. But you may not drive without a valid license, and the Motor Vehicle Division can take action against your license well before this case is concluded. So you need to stay up to date with the legality of your license. I'm not ordering you to report this to any licensing board because, to the best of my knowledge, people don't have to report arrests to the school licensing authorities like you do if you're a doctor or a nurse. You do have to report convictions. That being said, the court is very concerned about the allegations because the weight of evidence against you appears to be very strong. And addiction to fentanyl is not something that, in this court's considerable experience with it, has ever been stopped by anyone without substantial help. People don't just magically stop doing this. I'm not, you shouldn't say anything, Mr. Johnson. Here's why. You're already getting the best release from me that you can. Anything you say could potentially incriminate you, and it's not going to improve your release conditions. So talk to your lawyer. Your lawyer can give you advice, can tell your side of the story, can do lots of things. And so that's why if you really want to tell me something, I won't stop you. But it's almost certainly not going to help you today, and it could incriminate you. So in an effort to protect your rights, I would certainly encourage you not to talk about what you've been accused of, even though I know it's tempting when I'm expressing extreme concern about what's been alleged against you. But you do have your release conditions. You'll get instructions in an envelope about how to drug and alcohol test. You have to call after you get released. So don't lose that envelope. Everything's on your paperwork to the extent if you have a substance abuse issue. Your defense lawyer can even use negative tests to help establish that you are able to control it better than most at this point in time, et cetera. So there are actually beneficial reasons for you. I believe it's in the interest of public safety to require you to test, and as an added bit of accountability to try very hard to prevent you from getting behind the wheel of a death machine if you are under the influence. Cars make other people maimed and killed, and I see that every day. So these kinds of cases where people are accused of doing this right in the middle of a public intersection gives the court extreme concern about the safety of our community. So everything's on your paperwork, sir. If you step to your left, you get that copy. Don't miss your court dates. Thank you. Right, Mr. Crump Valencia, and then Julio Lopez Sanchez, will you go to the chair? Hello, sir. Can I have your full name and your date of birth?
Jason Crump Valencia, 04/23/1999.
Okay, thanks. Mr. Crump Valencia, you got arrested for 3 things. That is narcotic drug possession, a Class 4 felony, drug paraphernalia possession, a Class 6 felony, and criminal trespassing as a Class 3 misdemeanor. For purposes of this hearing only, I found probable cause on the trespassing, not the drugs, because the police did not provide enough information to legally support the allegation that that was illegal drugs. So talk to your lawyer about that. The charges aren't dismissed. I'm just not setting release conditions for them. I'm only setting release conditions as though you are accused of criminal trespassing, because that's all there's probable cause for. So talk to your lawyer about that. I do still need to send you to Superior Court because you're still accused of felonies. So I'm giving you a lawyer and setting your court dates in 2 weeks in the downtown Superior Court. The first one is the status conference, September 18th, 8:30 in the morning. That's about 2 weeks from now. Preliminary hearing, September 22nd at 8:30. The address is on your paperwork. So as I said, I'm going to release you. I want you to check in with pretrial services, though. It's not hard. You can do it from a public place. You can, if you don't have a phone or access to one, they'll tell you how to do in-person reporting. They'll work with you on that. You may not go to any part of that apartment complex. No weapons, no drugs without a valid prescription. It sounds like the police allege they've trespassed you many times and that they know you on site. So if you get arrested for violating that while this case is pending, you're almost certainly getting a bond. So don't go there while the case is pending. Everything else is on your paperwork, okay? If you step to your left, you get a copy. Mr. Sanchez, Lopez Sanchez. After that, Nicholas De Leon, we go to the chair. Mr. Lopez, right here. Hello, sir. Can I have your full name and your date of birth, please?
How you doing? Julio Lopez Sanchez, October 5th, 1981.
Okay, thanks. You're on a new case. You were booked in for allegations of possessing dangerous and narcotic drugs. Those are Class 4 felonies, and drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am not appointing a lawyer for you because, according to your financial profile, you don't financially qualify. How long have you had the job for Wire Fiber?
I've been working there for 2 years and a half now.
Okay, and do you rent or own a house? Or
I'm renting right now.
Okay. And so again, apologies, officer. I'm gonna give you a lawyer, Mr. Lopez Sanchez. State has algorithms, the county has math they use to decide if people are indigent, but it's this court's experience typically that somebody with your amount of income, especially if you have a substance abuse problem, can't afford lawyers. So I'm going to appoint one for you.
All right, thank you.
So I'm going to give you 2 court dates. That is a status conference September 18th at 8:30 in the morning. That's 2 weeks from now. Preliminary hearing September 22nd at 8:30. The address is on your paperwork. It's in downtown Phoenix, and you qualify for release on your own recognizance. I'm not going to make you report to pretrial. Looks like you don't have any criminal history we could find, so you just need to go to court and comply with your release conditions. With no criminal history, you may well qualify for a diversion offer, which means you do some drug treatment and some other things, and you never take a conviction at all. But you have to show up to get that offer. That's something offered by the prosecutor. You have to be there to see if you can get that offer.
I sure will be there.
Talk to your lawyer. Your lawyer will help you get the best result in this case that you can. Of course, you are entitled to go to trial on the case and defend yourself. So go talk to your lawyer. Just don't fail to show up for court.
Yes,
okay?
I won't.
All right, sir.
I won't.
If you take your paperwork, you'll be all done. Thank you.
Thank you.
All right, Mr. De Leon, Nicholas De Leon. And then Mr. Brame, Nicholas Brame, will you go to the chair? Right here, Mr. De Leon. Hello, sir. Can I have your full name and date of birth?
Nicholas De Leon, April 24th, 1989.
Okay, thanks. You're here on a new case, and you were picked up for allegations of dangerous drug possession, a Class 4 felony, and drug paraphernalia possession, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. Your next court date will be a status conference in 2 weeks, which is September 18th at 8:30 in the morning, with a preliminary hearing September 22nd at 8:30. The address is on your paperwork. I'm going to release you on your own recognizance. You have standard release conditions. Don't miss court. No weapons, no drugs without a valid prescription. And also, I put a note on your paperwork. This is honestly for your benefit and your lawyers. Apparently, you got charged in a criminal complaint from a while ago. I didn't look up the date. And they set a summons date of today, which means it's they mail you a notice to come to court. It came back undelivered. It was a bad address. And so you couldn't have been there this morning, plus you got arrested. But the reason I'm telling you and your lawyer is because it is not yet turned into a warrant. Typically, they'll try twice on most cases before it turns into a warrant. This way, you and your lawyer have that case number. So next week, when you go see your lawyer, be sure to say to your lawyer, hey, can you help me with this so it does not become a warrant? You just want to get on track with showing up for the court dates in that older case because we didn't find you. And the court date was today, but it says the notice came back undelivered. Does that make sense? It's a second case. It's not, I'm not seeing you on it. I can't see you on it. It's not in front of me.
Okay.
Right now, it's waiting for that court to do something. They're probably going to send a second summons to the bad address, and then it's going to turn into a warrant. So talk to your lawyer. Your lawyer will help you get it in front of the court so it never turns into a warrant, okay?
Okay.
All right, everything's on your paperwork. If you step to your left, you'll be out in a few hours. Okay?
Thank you.
Good luck, sir. Mr. Brame? Yeah. And then Michael Montano, will you go to the chair? Right here, sir. Hello, sir. Can I have your full name and your date of birth?
Nicholas Martin Brim, 18 September 1974.
Okay, thanks. You're on two things. One's an arrest warrant in a criminal case that was charged a long time ago, and one is a warrant from the White Tank Justice Court. So I'm going to start with the new, not that new, felony charges. All right, back in 2020, you were charged with possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. The alleged offense date is June 16th of 2020, and it's hard to see. It's the Mesa Police Department. All right, so you'll get a copy of the charges and police reports from your lawyer, and it looks like this was charged back then, October of 2020, and that maybe they tried to send a summons. Maybe they didn't. We don't hold that. They did try to send a summons. It just came back undelivered, and it turned into a warrant, which is what I was trying to warn that other guy about. We don't hold that against you, so don't freak out about that. We don't. That's not your fault. This is just the unpleasant way that you find out that was happening. So I'm going to appoint a lawyer for you, and you just start fresh with this case. You're going to have a status conference in 2 weeks, September 18th, 8:30 in the morning. Preliminary hearing, September 22nd at 8:30. The address is on your paperwork, and I'm going to release you to pretrial services. That's based on your criminal history, so you're going to have to call in and report into them. I did not hold the whole summons situation against you. We see this all the time. It's not your guys' fault, so don't worry. Just take it fresh from here, okay? Don't miss court dates. Report to pretrial services. Now, you're also here on a warrant from the White Tank Justice Court, where, just so you're not worrying, I am planning to release you, but this is a straight-up failure to appear. You got a court date from a judge. I can see it in the paperwork. And it was well before the start of the pandemic. But here's why I'm going to give you a do-over. Because it has been 5-6 years, and the pandemic happened 2 months after this warrant went out. A lot of people lost track of a lot of things. Not that, but actually, I think this is a more serious case. This is a DUI. DUI, as I told that other gentleman, makes other people die. I take DUI pretty seriously. But that being said, I just released you to pretrial in a felony. Your lawyer is going to be really mad at you in the felony case if you pick up a misdemeanor warrant. So I think you have an added incentive to show up in the misdemeanor case because you got a bigger problem, which is the felony case. You need to not be picking up warrants in misdemeanors. So I'm going to send you to the White Tank Justice Court. I believe they appointed counsel for you a few years ago when you were here. But if they didn't, you can just requalify when you get there. What I show is that you were IA January 5, right here in this, well, probably not this courtroom, probably 4th Avenue. And then you failed to appear January 21st of 2020. And so I'm guessing on January 5th of 2020, they did appoint the public defender for you. So I'm not redoing it, but if you get there and you don't have a PD, ask for one.
I actually did show up there, and I wasn't on the case. I had to go back home. I contacted, my mom just passed away, and I used her family attorney, Carl Toodle. I went back out there a second time, and the stuff that had happened, I know you want to hear about it all, but
yeah, and I'm releasing you anyway.
It was chemotherapy, so.
Okay, so just don't FTA. What I'm telling you is,
but I did appear, and I don't know why it's here. That's why I was really surprised last night when they picked me up.
Why there's a warrant?
For 3 years, I carried around paperwork that was a dismissal with prejudice.
Oh, wow. Okay, well, listen.
I don't know why it was there.
Take that paperwork, if you can find it. Go to court. Go to White Tank, because I'm not seeing any record. I'm not seeing, because I can look at, I have limited access to the Justice Court records. I don't see anything in here that looks like a dismissal. So I don't know what that is. You just need to go work it out with them, okay?
Right, and I know people say stuff all the time, but
they do.
My car got stolen a year ago, and that's, but I carried it with me, because I know stuff happens. I've dealt with it in the past. I showed up at every court appointment, everything that I knew existed, I went to.
Right. Even if I assume this is what it looks like, I'm letting you go for the reasons that I said. But because I'll tell you, you do it again, you're gonna get a bump.
Man, so I haven't drank in 13 years because of chemotherapy and everything else.
And I literally did put on my written order on the totality of the circumstances, including no police contact for at least 5 years. So one thing I know is you haven't done anything to get the police's attention in 5 years, which is an odd point in your favor. It's not always a point in someone's favor. I'm looking at it as a point in your favor, so.
I actually worked with them a lot, helping with overdoses and stuff.
Oh, okay, okay, I was gonna say, I thought you were gonna say like.
No, I helped.
Informing, I was like, don't say that in the public.
No.
All right, so.
I heard you before, but.
Helping with overdoses is very admirable, and that's good. All right, so
Okay.
arraignment hearing in the White Tank Justice Court is September 23rd at 9:30 in the morning. Just be there. And you know, like I said, if they don't show as the PD being appointed, it's a DUI. You can get a public defender, so just tell them.
Okay.
The judge at the jail thought that I had gotten one in 2020. Can I have one today? And then get that person to help you with the overall situation, okay?
And
All right.
so, just to clarify, the very nice guy who helped me earlier said I would leave here with a card with a lawyer's phone number on it. So that is no longer the case. I will not get that until I.
No, you should. Does he have the yellow sheet, officer, the PD sheet? Because I gave him a PD in the felony case. Okay, we're going to get you, I'm glad you asked, because the public defender is going to represent you, may not be the same human, but their office is going to represent you in the felony case and the justice court.
Yeah, the White Tank's a very unique place to go.
Well, so call that number and say, maybe I should, okay, I'm going to they get annoyed if we reappoint them when they've already been appointed, but who cares? It's no harm.
I've never even talked to the guy.
So let's reprint in the Justice Court, officer, because I'm going to expressly appoint the Maricopa County Public Defender in your White Tank case, so that they are very clear, they assign it to a human, and that person is prepared when you get there on the 23rd.
I'm not laughing at you.
No, I understand. And that way they can help you sort out this business. Was it dismissed? Was it not dismissed? If not, why did you think so?
They had no public defenders available, so they had to go and pay a regular attorney.
Oh, okay.
That's what I was chuckling at.
So I don't need, honestly, right. I set you up as best as I can to get legal advice. So good luck with that, and you can call them in advance if they have your file, but at least my order will alert them that somebody named Nicholas Brame needs to have a PD there on September 23rd. So good luck.
And that is the status, correct?
Correct, and it's technically an arraignment hearing, but yes, in the Justice Court. Then in the felony case, though, your court date, I think, is the 18th and the 22nd. So all three of those court dates are on this paperwork, and you're going to have the same agency representing you for both, but it may not be the same human. But if you step to your left, you'll get your paperwork. All right, good luck, sir.
Thank you.
Sure. Mr. Montano? All right, and then, officer, I'm going to do my house calls after Mr. Montano if we can get some traffic run before I know. Okay, thanks. All right, Mr. Montano, can I have your full name and date of birth?
Michael Moises Montano, April 30th.
Apologies. You're saying I have one before. So hang on one, sir. What's your name, sir? Yours, yeah, in the white shirt. Okay, we had you as a house call. I'm going to do Ulibarri, and then we'll run traffic. Yeah, okay, thanks. Okay, sorry, we were showing that you weren't in court. Okay, you'll be next. All right. Sorry, Mr. Montano. Apologies. You got arrested for possession of narcotic drugs, a class 4 felony. I'm appointing a lawyer for you. I'm giving you 2 court dates. September 18th at 8:30 in the morning, that's a status conference. Then a preliminary hearing September 22nd at 8:30. The court address is on your paperwork. I'm also releasing you with no conditions because I didn't find probable cause on this charge. The police didn't provide enough support for the allegation that what you had was illegal narcotics. So talk to your lawyer about this. The case is not dismissed. I am just not setting release conditions for it. You're entitled to be released, which frankly, with your criminal history, I'm sure I would have done anyway on this type of charge. That being said, you don't have any other conditions except come to court. I also put a phone number on your paperwork. You might want to call that a few days before the 18th. Just verify that your court date is going forward, because sometimes in cases like yours, the state may wait for laboratory results before they decide to go forward, in which case the court date will vanish and you'll make a trip for nothing. So maybe call a few days before the 18th and just say, do I still have a court date on the 18th?
Okay, so they pulled up on me a misidentity at Circle K.
Oh, okay. Well, and none of that, has been held against you here.
Okay, gotcha. They're calling me Timothy, and...
Oh, well, if you're thinking it was like a bad stop, you can talk to your lawyer about that next week.
Okay.
I'm releasing you, and so just don't miss a court date. A few days in advance, call the number, make sure you still have a court date, just so you don't waste a trip, and then take it up with your lawyer if and when the formal charge gets filed, okay? All right, if you step to your left, you get your paperwork. Good luck. All right, Mr. Ulibarri? Right here, sir. Hi, sir. Can I have your full name and your date of birth, please?
Samuel Lino Ulibarri, 7295.
Okay, thanks. You're on a justice court warrant from Hassayampa Justice Court in a criminal speeding case. That's a class 3 misdemeanor. This is a failure to appear warrant from December 8th of 2022. And so I'm going to give you a court date of September 9th, which is this Tuesday. Yeah, it's this Tuesday the 9th at 8:30 in the morning. The Hassayampa Justice Court is up in the Northwest Valley. The address will be on your paperwork. Your bond is $100. It is secured. If you post it, comply with all of your written conditions. Don't miss that court date. I recognize it is only a class 3 misdemeanor, but it has been a lot of years, and you did come in on a new case. It didn't get filed in this court, but the way that the court found you for this case was you came in on a new charge. So that's why you're getting a bond. If you post it and you don't go, you'll lose the bond money and the bond will go up. If you step to your left, I'll give you paperwork. Thank you. Thank you. Okay. And she's clearing right now, counsel. Okay, let's get Mr. Morris in, please. Right here, sir.
Yes, sir.
Correct. All right. Sir, let's have your full name and date of birth, please.
Caleb Morris, 6/15/92.
Okay, thank you. And then the appearance of both counsel, starting with the state, please.
Brooke Gahn on behalf of the state.
Good morning, Your Honor. Daniel Hutto appearing on behalf of Caleb Morris virtually. Thank you for granting that request.
No problem. And so, Mr. Morris, I'm going to be able to see and hear the lawyers. We have a monitor where you could normally see them, but it's apparently not working. So you're going to be able to hear them. All right. Mr. Morris, you were arrested in a new case. The allegation is one count of child abuse by criminal negligence as a class 6 felony. And the court is inclined, based on what's been presented, to find probable cause for that. Before I move to any consideration of release conditions, did the defense want to be heard on probable cause?
Judge, just briefly, I did want to note, that I understand probable cause is a very low standard and threshold, and I appreciate the judge's inclination, and I understand that based on the Form 4, it does appear that Mr. Morris did admit to spanking the 6-year-old minor child, but corporal punishment is not a crime in these circumstances. It's alleged to be a hand. It was not a device, a belt, a paddle, etc. The officers noted significant redness and a hand mark. But when I read, the definition of injury and I read the definition of, the class 6 under circumstances other than those likely to cause death or serious physical injury, I don't believe there's probable cause, but I'll leave it to get in that minor argument.
All right, thank you. And I'm not going to hear rebuttal from the state because I don't find that rebuts what the police have alleged, Mr. Morris. Among other things, they allege what appeared to be raised welts, and the court believes there is probable cause to believe that even in the context of corporal punishment, that was negligently excessive. And so there's at least probable cause for that. And as your lawyer noted, probable cause is not a high standard. It is below preponderance of the evidence. So that is at least probable cause. And I would have found that for the red marks as well, but certainly a welt, the court does find probable cause. That exceeds your legal right to discipline a child by striking them. So, in any event, I'm not appointing a lawyer for you because you've hired Mr. Hutto. Is that for the whole case, Mr. Hutto, or limited?
For today, it was a limited scope notice of appearance, Judge, but we'll...
I don't think he's indigent anyway. It's difficult. Honestly, it's difficult. He's saying that he's been an Uber driver for 4 days, but his expenses are over $8,000 a month. So, counsel, on that, I'd rather see him fill out an affidavit downtown. And if he is understating his income, he'll have to do that under oath.
Understood, Judge.
All right, so.
And then
Go ahead,
I'll wait for the state's position, and then we can talk about release.
Yes. Yes, thanks. And don't let me forget to give you dates, because I often do in these situations. Counsel for the state, your written recommendation was for pretrial services release. I am inclined to do that. Did you want to be heard much more on it or change your recommendation? Go ahead. We can't hear you.
Can you hear me now, Your Honor?
Yes.
Okay, I apologize. Yes, the state's recommendation is for pretrial services release. Obviously, the state does believe that these are serious allegations and this is a serious situation. But given Mr. Morris's lack of any criminal history, I think that pretrial services, along with the restriction for only supervised contact with the victim and his other minor children, that is sufficient to ensure the safety of the victim, Your Honor.
So let me clarify, so I'm sure I understand the state's request. The state is asking the court to permit him to have supervised contact even with the alleged victim and supervised contact with each of his other children?
That's correct, Your Honor.
All right. And Mr. Hutto, I'm going to go to you next. I am not inclined to permit any contact with the alleged victim. I was inclined to permit contact with the child witnesses, provided that Mr. Morris does not attempt to or respond to any discussion with them about the facts of the case. And as I sometimes do, I'm planning to cite the witness tampering and witness and influencing a witness felony statutes for Mr. Morris's education. But Mr. Hutto, what did you want to say on conditions of?
I think I can, I appreciate the state's position, and I understand that that's a unique one. In my experience, Your Honor's initial inclination is what we may see or tend to expect for a case of this nature or any other domestic violence allegation. But to assist Your Honor in understanding why the state may have that position and why we believe that that's appropriate, I am asking for OR release, but mainly because of the prior no criminal history whatsoever for Mr. Morris. Also citing that he was cooperative with the police when they appeared on scene, and he was forthcoming. He did make a statement or admission to his conduct. There's a lot of collateral issues for Mr. Morris and this family in particular. The reporting party, the children's mother, there's a pending family law case already. Judge Coffey issued temporary orders on July 18th, 2025, designating Mr. Morris.
Let me stop you right there, please, because I would like to look that up. And it wasn't hyperlinked on my screen. All I got was a denied order of protection for the mother, and I saw a reference from trial saying your client has an order of protection. I presume that's against the wife or ex-wife. And so I already saw that we had some competing orders of protection business. I was frankly surprised not to see a family court case. So give me a second.
Would you like that FC number, Judge?
I would, yeah. Hold on a second, because I'm going to have to pull it up. What is it?
FC 2025 091863.
Okay, thanks. Sometimes they don't hyperlink because the name is slightly different. Who knows why?
Yeah, I've run into that too. Well, not the hyperlinking, but yeah, like the formerly known as or other names for surnames.
Our system doesn't.
I can resume my summary when Your Honor's ready, or if you'd like to look at those orders first.
Oh, that's what I'm thinking. Is let me have a quick look here. 2027 091863. Okay. Yep. Here we go. I want to see the temporary orders. It doesn't mean they'll make any difference to me, but I would like to see them. Okay. Let's see. Goodness, what date do you have? Oh, I see. No, do you have? Okay, temporary orders hearing 7/8. Okay, here we go. 7/18. Yeah, I've got it. Number
July
40.
18th is when I have it filed.
lot of boilerplate in these orders. Hold on. Important boilerplate, but. All right. Joint legal decision-making.
With Mr. Morris having final say.
Specific joint and final decision-making. Okay. Okay. Oops. And if there's one child, we don't have to go naming them here. There's one child at the bottom of page 2 as to whom it's just straight up joint and it doesn't say.
Yep. Doesn't say final
break.
for that. And so
is that the alleged victim in this case?
No, Your Honor.
Okay.
If I may,
I didn't think so. Yeah, go ahead. Keep going.
I would say it may help in interpreting these orders. So ultimately, the court found that and designated Mr. Morris the primary residential parent for the party's 8 minor children. It is a very large family. The court also, but as it relates to the one child, KM, for the purposes of the record, the 2 witnesses that are teenage daughters in this case that are referenced in the Form 4, those are adoptive daughters of Mr. Morris. He is their legal parent. The father's rights have previously been terminated by the department and the juvenile court. And so, without getting into too much detail, but one component of the family law case that I am not involved in directly, but I have come to understand, these adoptive teenage daughters, there's current tension in the family dynamic between father and mother. Without being too presumptuous, teenage daughters are difficult in any event, but in this particular case.
And without being presumptuous, over-controlling parents can exacerbate that situation to a large degree. And if, as alleged, somebody is constantly threatening to kick a child out, the court is concerned that the tension is running both directions. So I'm just saying, counsel, I'm not a family court judge, but I decline to assume it's just obnoxious teenage daughters. But I'm not making assumptions either direction. Please don't try to oversell that. Go ahead.
Okay. So ultimately, Your Honor, because of the 8 minor children and father being designated the primary residential parent for all 8, we do believe that it's appropriate that he be able to return to the home, which is a standard condition that's typically not granted, but he's got to parent these children somewhere. My understanding is that all the children are with the paternal grandparents presently. Last night, law enforcement gave the children to Mr. Morris's parents, who have helped parent during the pendency of their lives because of it being a large family, especially after the custody case. So they have familiarity with all the children. I think they were there as most recently as this last weekend with the children. So I do believe that he should be permitted contact with all of the minor children because of the current temporary orders, as well as I believe that the paternal grandparents would be sufficient for supervision. They are both local. They do not have fitness issues. They were not brought up in the minor or in the temporary orders, where in comparison, mother's not permitted to have overnight time if her father is around. There's some sexual abuse allegations against mother's father that were one of the fitness issues in the underlying custody case. So ultimately, my position, having practicing both family law and criminal law, in the criminal context, it's best to allow orders that are flexible, but also protective, and allow the family court to make more specific findings, or the department. I understand the Department of Child Safety was contacted yesterday as well. They may or may not intervene and file some sort of a dependency or a termination or severance. But so our request is similar to the state. I do believe he should be permitted to return home. I believe that he should be permitted to have contact with all of the minor children, including the alleged victim, who is 6. Because alternatively, I don't know where these children would go, and then we would require the department to make immediate orders. So I think, given his lack of history and given the allegations in this case, all serious, although easily correctable, I think contact is appropriate as we requested. Again, and the paternal grandparents are Miss Maggie and Michael Morris. And again, they live local within the Maricopa County jurisdiction.
Given, I've been reading the defendant's lawyers filing the pretrial statement for the temporary orders to get to the allegations about maternal grandfather. It's difficult for this court to know, and I'll say, you know, to know what, if any, portion of Judge Coffey's order relied on that, because of all of the things listed in here. This sounds ill-developed in the record. And so I don't know to what extent Judge Coffey may have relied on that. But it sounds like the 6-year-old can go to the paternal grandparents, to his parents' house. And I am far more inclined to do that, because what this court is extremely concerned with, and certainly, Mr. Morris, you talked to your lawyer, you have a corporal punishment defense. I see that. I recognize that. This court believes that raised welts and that level of violence against a 6-year-old is beyond corporal punishment and into the realm of assault. And so the court is very concerned about that 6-year-old. I hope the department is concerned about that 6-year-old, because a 6-year-old almost entirely lacks the ability to protect themselves. And so clearly, your case, your family court case, is deeply fraught. And that is not before this court. I wanted to get some idea whether there was anything in there this court felt it could rely on in trying to sort some of this out. But this court is deeply concerned that you having contact with the 6-year-old will result in witness intimidation and perhaps some more violence against the child. That again, I believe there is substantial evidence to support probable cause. That I'm sure people can debate whether a spanking for a lack of room cleaning should result in raised welts. This court believes it should not, and that is negligently accomplished. Okay. So, in any event, counsel, do you want to talk to your client about the 6-year-old's ability to remain at his parents' house?
I have not had that opportunity to talk with him about it. I did talk to both paternal grandparents. They're the ones who contacted me at the 11th hour about Mr. Morris's arrest.
Okay. This is what I'm going to do. So, again, this is not a family court, and my orders will trump family court orders. It's very clear, and it supersedes any order of protection. So, this is what I'm going to do. I'm going to stick with what I was doing. I was not going to prohibit you from going there because I'd already triangulated that the kids were living with you. I'm very concerned about witness intimidation. Clearly, there is a problem between you and some of your children. That cannot be allowed to include this case. So that doesn't mean that means you can talk to them about their school, their lives, everything. But you can't say, thanks for calling the police. You can't say, don't you dare say anything. That is all potentially a felony. I put the statutes in there for your own education. And the court's very concerned. Even if the girls are flat out lying, you are not to intimidate them or attempt to influence their testimony. That is illegal. So I'm also on a child safety standard. This court believes that the safety of your 6-year-old is paramount. And that, so what I'm going to order is that you not live where she lives, you not have any contact with her. Where she lives is currently up to you, I think, with this final say on the decision making. That can be with your parents, that could be with your mother. Consult with your lawyer in the family court case about that, but you can't live where she lives. So if you can find her another place. If you can't, then you have a problem and you're not permitted to excuse yourself from this court order. This is a violent offense that has been alleged against you, having been performed negligently on these allegations. But the court takes it extremely seriously. And the overall picture of what's happening in your family is a volatile situation. And so the court does not want the 6-year-old returns to the volatile situation where she's unable to protect herself. I believe victims' rights require this order. So you can figure it out. Where does the 6-year-old stay? Just not with you. And so I'm not going to do any kind of ankle monitor because there's no location really to keep him away from. Also, you don't have any criminal history, Mr. Morris, and I recognize that. But I do want you to report to pretrial services. I want you to inform them of where the 6-year-old is staying. And as I said, I'm going to order that you may have contact with the child witnesses. I listed them as ages 8, 15, and 16 because that's how they were listed in the police narrative, but your lawyer can help you figure out who that was. So long as you do not discuss or attempt to discuss the case with them, that means if they start it, you have to say, I cannot talk to you about that. And same with your spouse/ex-spouse. She is also a witness in the case. But with her, you can talk to her to the extent that such contact is already permitted under any other court order. So if you have other court orders that limit your contact with her, you have to comply with those. I'll let those orders control. But you're still not to discuss this criminal case with her. You can discuss whatever you're already able to discuss with her in other cases. You guys are represented by counsel. So you can have contact with her because you're going to need to for parenting time and all that kind of stuff. But don't discuss this case with the divorce is not final, right? So it's just spouse?
These are temporary, correct, Your Honor?
Okay, so I wrote ex-spouse, but so your spouse. You can have contact with her. Don't discuss this case with her, and don't discuss the case with the child witnesses. Mr. Hutto, anything else?
The only other thing I'll put, Judge, is I know that there's often a no contact with minors if there's a child victim crime alleged. I just want to make sure that there's no conflict with that standard language.
I did not order that.
Okay, thank
no.
you.
Your Honor.
No, this is a negligent offense, and he has no criminal history. Ms. Gaunt.
Thank you, Your Honor. And just for clarification on the orders regarding the children. So regarding the other 3 non-victim children that were discussed in the Form 4, the court is restricting his contact to only supervised. Is that correct?
I'm not, no.
Okay. And then my other question would be, there appears to be 4 other children that are subject to the family court matter that are not discussed in the Form 4. I'm concerned specifically my concern is if these are children under the age of 6 and potentially children who are nonverbal, that gives me even more concern about him having unsupervised contact with 4 smaller children. Additionally, I would ask the court for a specific order that Mr. Morris be prohibited from engaging in corporal punishment while this case is pending.
Oh, well, now I will say I saw 1 kid in the family court orders that's younger. Is that correct, Counsel Hutto? There's one kid younger than this one?
There's one child that's younger than the alleged victim, but I believe, Caleb, correct me, 4 or 5 years old, so verbal would be able to report or speak to any older siblings if there was a concern.
So, Counsel, I share your concern. I do, because as Counsel may or may not be aware, this court, not just the Maricopa County Superior Court, but the initial appearance court, we review and issue all of the child removal orders for the entirety of the state of Arizona. So I've read hundreds and hundreds and hundreds of descriptions of family conflict, things like this. And there are many red flags present, Mr. Morris, but I'm not here to figure out whether you need some assistance with your parenting style. I have, a limited function with respect to the criminal case. I share Counsel Gaunt's concerns about your other children, but on these specific facts, and again, with your lack of criminal history, I am reluctant to go too far down that road because there are red flags. Are there red flags? Absolutely, Mr. Morris. This court is very concerned that you have a dominating and occasionally overly harsh parenting style, which, Editorially, the court believes never results in good relationships with one's adult children, but people get to parent how they want within a wide standard. And that corporal punishment is, in fact, legal. But I believe that your client doesn't have a vested right, and this court can prohibit things like weapon possession, which I just did, and I always do in domestic violence cases, because weapons and domestic violence are a bad mix. So I am prepared to order that Mr. Morris is prohibited from employing corporal punishment against any of his children while the case is pending. Would you like to be heard on that, Mr. Hutto?
No, Your Honor, I'll defer to the court, although I apologize, let me rephrase. I've seen that ordered in family courts in which we are able to accurately flush out and take the time to determine if there's a dominant and overly harsh parenting style, as the court cited. I think that may be a premature order. However, I think Mr. Morris has been put on notice that any type of corporal punishment could result in serious felony charges. But again, in my context, I've seen that that is most appropriate for a family court.
All right. I get your points, Mr. Hutto, but I believe this court's broad authority to issue orders that are in the interest of the safety of the community and or any alleged victim, it's very generalized. I think that is within it, and it is along the nature of the kinds of things this court believes will add to the protection of his other children and of the child witnesses while the case is pending. And if there is reason to question his judgment in the application of physical discipline of his children, this court believes that that is a legally supportable order, and I think it's warranted. So I am gonna order that, Mr. Morris. And as far as whether your parenting style is harsh or overly dominating, I will certainly leave that to the family court. I'm not factoring that in one direction or the other. Obviously, the family court has its work cut out for it. This court intends to protect the safety of the 6-year-old victim and, to the extent appropriate, which this court believes that is appropriate, Mr. Morris's other children. I'm going to order that. There are many, many means of discipline available for parents. This court is not precluding Mr. Morris from disciplining his children, simply from laying hands on them while he's doing it. So, anything else, Mr. Hutto?
No, Judge, I appreciate the other orders. Thank you.
All right, thank you. And State? Okay, it looked like a no thank you, but I had to read your lips.
Yeah, no, thank you, Your Honor.
Okay, then we're going to get that printed out. We will email you a copy, Mr. Hutto, and Mr. Morris, you'll get a copy before you leave. You'll get an envelope about, go ahead.
Reminder about dates, Judge. We haven't talked about dates yet.
Oh, thank you. Told you to remind me. All righty, status conference, September 18th at 8:30 in the morning. That's in 2 weeks in the downtown Superior Court. Preliminary hearing, September 22nd at 8:30. The address, Mr. Morris, will be on your paperwork. And don't lose that envelope. The envelope tells you how to report into pretrial services after you get out, but you'll be processed for release. It is my belief that you should be out by dinner time, but release is very slow, so try to be patient. All right, then the council is welcome to disconnect. Thank you for your time. Have a good day. Thank you. All right, then I've got 2 house calls. Brian Daniels, officer, and Samuel Venegas Barrera. Are they not physically present in court because they've been isolated by the sheriff's office as a possible risk to themselves or others? Have they been isolated as safety risks, officer?
Yes, no.
Yes, okay. I did get an affirmative answer from the sheriff's office, so I will see Brian Daniels and Samuel Venegas Barrera in-house to conduct their initial appearances in person immediately after this recording. I'll advise Brian Daniels, warrant 51192, that he's here on a new case. He got booked in for dangerous drug possession, class 4 felony, drug paraphernalia possession, class 6 felony. I did not find probable cause for either one of those, and I am appointing a lawyer for him. His next court date will be a status conference, September 18th at 8:30, and a preliminary hearing, September 22nd at 8:30. I'll advise him that he needs to go to court. There could be a warrant if he doesn't, but that he doesn't have any other release conditions because I did not find probable cause. Samuel Venegas Barrera is here on, Venegas Barrera is here on 2 matters, a new one and a probation case. In the new one, he got accused of burglary in the third degree. It's a class 4 felony, and there is probable cause for it. I am appointing a lawyer for him, giving him court dates of September 10 and September 12 for a status conference and preliminary hearing, respectively, both at 8:30 in the morning in the downtown Superior Court. On these facts, I am inclined to set bail in the amount of $2,500 secured with written release conditions I will go over with him, including no contact with the alleged victim and no going to the scene of the crime. Mr. Venegas-Barrera is also here on a page 2, term 1 hold for his probation violation. He's on felony probation. The probation department will be filing a petition to revoke based on his new arrest. So I'm appointing a lawyer and giving him a court date of September 11th at 8:30 in the morning in the downtown probation court for a revocation arraignment and possible disposition hearing. Currently inclined to set bail in that case in the amount of $1,000 secured with written conditions I'll go over with him. If anything changes after I conduct these initial appearances, I'll put my final decision in my formal written order, and interested parties should look for it there. It is not this court's intent to update the recording after that. I'll just put it in my written order. All right, we're going to stand in recess then until 2 p.m.